Rise.
In the Court of Appeal Criminal Division, the case against Mr Malkinson is a reference by the Criminal Case Review Commission under Section 9 of the Criminal Appeal Act 1995. This is also a case where the Sexual Offences Amendment Act 1992 applies and the victim is thus entitled to anonymity.
Thank you, my lords. This is a reference, as the court knows, by the Criminal Cases Review Commission under Section 9 of the 95 Act in respect of the appellant Andrew Malkinson's convictions for attempting to choke, suffocate or strangle with intent to rape, vaginal rape and anal rape. And at the outset, if I may, my lords, may I spend a very few minutes setting out the context of this most troubling identification case, which may have, depending upon the view of this court, wider implications for the administration of criminal justice, given what we contend, and for this I will require the court's leave, serious and highly significant disclosure failures at trial, which represented a fundamental departure from the Criminal Proceedings and Investigations Act in the court below, and also frustrated the proper administration of justice when this matter first came before a constitution of this court in 2006. Now, I realise I do require leave for that, but if I may just set out the context at the beginning, because disclosure failures were only uncovered 15 years after Mr Malkinson's convictions, representing, my lords, not only the denial of his Article 6 rights at trial, but, as I said, a denial of those rights at his first appeal, depriving him of twin possibilities in accordance with the law. The realistic possibility at trial that he would not have been convicted, or that a previous constitution of this court would have quashed his conviction back in 2006. So, my lords, in more than one sense, therefore, this is an historic case, but also an historic injustice. The respondent, represented, as the court knows, by my learned friend Mr Price, together with his junior Mr Greaves-Smith, joins with us in submitting that DNA testing, which Mr Malkinson had called for since his arrest, some 20 years ago almost, now supports his long-standing protestations of innocence. But also, as the court knows, those DNA tests, that fresh review, points to a credible suspect who could not be the appellant. And I say that because, in contradistinction to, for example, the case of Victor Nealon, none of the DNA, after the most exhaustive testing, could have been contributed to by the appellant, Mr Malkinson. None of it at all. So the respondent joins with us so far as ground one in submitting that new DNA evidence renders the appellant's 2004 conviction, based entirely upon identification evidence, including fleeting identification evidence, unsafe. But as the court appreciates, and I recognise that the court does not come fresh to this case, the appellant goes further than that and contends that his original trial resulted in an unsafe conviction because of deplorable disclosure failures, which must lie at the door of the Greater Manchester Police. Grave, we submit, and repeated disclosure failures during those proceedings that wholly undermined any prospect of a fair trial guaranteed under Article 6. Now, my lords, the respondent opposes the appeal so far as those grounds are concerned, grounds 2 to 5, and submits that the court should limit its finding to ground one, but as I have already submitted, and of course it is entirely a matter for your lordships, it's not the consensus view of the appellant and the respondent that matters, but nevertheless the respondent has already conceded that the appellant's conviction is unsafe as a consequence of the scientific evidence, and states in a respondent's notice that the appellant need establish no more. We respectfully submit that the respondent has adopted perhaps an unsatisfactorily narrow focus. I assure the court, notwithstanding the submissions that grounds 2 to 5 are irrelevant and that this court is not a court of inquiry, I assure the court that I am not here to waste its valuable time and resources, nor ask it to sit as a tribunal of inquiry, but I am attempting to ensure, together with my learned junior, Mr Hardy, the widest vindication, the widest possible proper and condign vindication for Mr Malkinson, and also, given that this is an identification case, to prevent others from suffering the same fate in the future, thus saving this court time. No one else, we submit, should have to go through what Mr Malkinson has endured, that is, the personal submission made on behalf of the appellant. But there are wider implications for the criminal justice system. As the court knows, and if I may go now very briefly to the authorities bundle which the court has electronically, but at tab 4 of the authorities bundle, there is the case of Ivan Fergus, which is reported in volume 98 of the Criminal Repeal Reports at page 313 for the year 1994. And that was a case of a fleeting encounter, fleeting glimpse identification. This case, the prosecution case at trial, was a difficult identification so far as the complainant. There is no doubt that she genuinely and honestly believed that she had correctly identified the right man, but that it was an identification made in the most traumatic and difficult circumstances, but it was otherwise unsupported. But the court in Fergus, which was, in our respectful submission, an extremely strong court, Lord Justice Steyn, as he then was, Mr Justice Hutchinson and Mr Justice Rougier, before turning to the specific grounds of appeal, addressed at the bottom, or to, no, forgive me, the middle of page 317, which your lordships will find electronic pagination 48, at the top of page 48, addressed the approach of our law, the English law, the law of England and Wales, to identification. Lord Justice Steyn stated, the issue of the identification of an offender is possibly one of the commonest questions of fact that juries have to consider. It is also one of the issues most susceptible to error. Visual identification of an offender not known to the observer is a particularly fallible process. Trial perception was powerfully, was powerfully articulated in the Devlin report, and then it cites at paragraph 8.1 of the Devlin report the following: we are satisfied that in cases which depend wholly or mainly on eyewitness evidence of identification, that there is a special risk of wrong conviction. It arises because the value of such evidence is exceptionally difficult to assess. The witness who has sincerely convinced himself and whose sincerity carries conviction is not unfrequently mistaken. And then at page 318, and I go to the final paragraph on page 48, the court cites Turnbull, that landmark decision of this court, and then, after quoting Turnbull, proceeds as follows. This observation may appear to be trite, but it is important to note that the trial judge's duty to withdraw the case from the jury in an identification case is wider than the general duty of a trial judge in respect of the submission of no case to answer as enunciated in Galbraith. Then I omit words. Secondly, Turnbull requires the judge to warn the jury of the special need for caution before convicting the accused in reliance on visual identification, and to explain that a mistaken witness may be a convincing one. That means that the jury ought to be told that honesty as such is no guarantee against a false impression being so indelibly imprinted on the mind so as to convince the honest witness that it is wholly reliable. And then over the page, and I omit words, line 4, while we do not wish in any way to decry the value of such general guidance to the jury, it seems to us that there is, in the interest of justice, a more important requirement. In Turnbull, the court stated, finally, he should remind the jury of any specific weaknesses which had appeared in the identification evidence. And before leaving Fergus, if I may ask the court to turn to page 54 of the electronic bundle, which was a unanimous recommendation by the court. And I don't need to address it in detail, but what the court was submitting was that, providing guidance. What the court was providing guidance in respect of was the unusually important nature of disclosure in identification evidence, namely first descriptions and photographs which should ordinarily be sent to the Crown Prosecution Service, they having heard from learned prosecution counsel Mr Lawrence Alt that that was not commonly done, and they were also of the mind that both prosecution and defence counsel should be aware of those disclosure obligations. So disclosure is unusually important in identification cases, particularly, my lords, where it is the only evidence, as it was in this case. Now, your lordships, the reason I submit this is that there are two ways of disposing of this appeal, and I hope without presumption. I will, of course, address the court in detail, but I hope without presumption, if I may, for the purposes of argument, given the concession by the Crown, given the fact that they have concluded that they cannot, with responsibility, argue against ground one, that the court could keep a very, very narrow focus and simply dispose of this matter, were it minded to, on ground one alone, and not address grounds 2 to 5. That, we respectfully submit, would be, in our submission, most unfortunate. I can take the court to the probanda in Hamilton, should the court require me to. But the appellant has spent 17 years, 4 months, and 16 days in prison, we submit, for a crime he did not commit. He did not. He spent nearly 3 times the specified period imprisoned because he would not falsely confess to abhorrent crimes which he did not commit. And it is the law which should drive this court to consider grounds 2 to 5, because we respectfully submit that, consistent with McInnes and the Lord Advocate, Acamo, and also Garland, which I am shortly to take your lordships to, that is the proper exercise of this court's time to let the court decide, for it is the court's decision, that the court, with its duty of decision, would conclude on the grounds thus enunciated that there was a realistic prospect of an acquittal, or, to put it negatively, that the conviction would not stand had proper disclosure been made in 2004. And further, we submit, if proper disclosure had been made in 2004, it is arguable, we submit, that there would not have been a case, or the case would have been dismissed at the close of the prosecution case, and a submission of no case to answer would have been upheld. Now, having set out that argument, if I could support it by citation of those authorities and the specific issues that we respectfully submit the court must have in mind, as opposed to dealing with this, as it were, and I do not mean this facetiously, the intervention of the deus ex machina of fresh scientific evidence. That will, we respectfully submit, quash this conviction, there is no doubt, and I hope I'm not presumptuous. But grounds 2 to 5 explore the denial of Article 6 rights, which would, as a realistic possibility, have led to this man's acquittal in 2004. Could I ask the court, therefore, to turn to Gianni Acamo, which is tab 1 in the electronic bundle. Again, a constitution we respectfully submit of this court, a strong constitution. Lord Justice Flo, Mr Justice Haddon Cave then was, and Mrs Justice Sheena Grubb. The facts are perhaps not terribly instructive, but what I can ask the court to go to is paragraph 25 at the bottom of page 6. When I say they're not particularly instructive, I can only submit that this was a case where the defence were arguing, without the benefit of knowledge of Mr Santos's previous convictions and other material that was damaging to his character, that his identification was dubious and unsatisfactory. And we respectfully submit that the same would precisely apply to Miss Craig and Mr Seward. At the bottom of page 6 of the electronic bundle, there is paragraph 25, which sets out the test. It is effectively common ground that in a case such as the present, where there has been non-disclosure of material by the prosecution at trial, and the issue arises in this court as to whether there was a fair trial and the conviction was safe, that two questions arise. The first is whether the material which was not disclosed to the defence, here the conviction of the prosecution witness, was material, and we respectfully submit that the convictions of Miss Craig and Mr Seward were material. Proceeding to paragraph 26, the second question is whether, notwithstanding the material non-disclosure, the trial was nevertheless fair. The test to be applied in answering that question is whether there is a real possibility that if defence counsel had been in a position to use the undisclosed material at trial, the jury would have arrived at a different verdict. If this court, and I emphasise that, if this court answers that question in the affirmative, the appeal should be allowed, and then there is the citation of McInnes and Her Majesty's advocate. And if I might ask the court to go now to McInnes, and the court will, forgive me, first of all, if I may, because it's first in the bundle, if the court please would go to Garland, which is at tab 5 of the electronic bundle. And at Garland, I go straight to the paragraph at 55, 55, the court, having exhaustively and carefully analysed the law, in particular McInnes, beforehand, and this is the conclusion they reach. This court has to apply the law of England and Wales as laid down in Pendleton, Burridge and Ahmed. In doing so, we have had regard to the question of what impact the withheld material might have had on the jury. The court's assessment, in other words, of what impact the withheld material might have had on the jury. The ultimate question for our consideration, however, is whether that material causes us to doubt the safety of the conviction. And on to McInnes, if I may, which the court will find at tab 11. And this was an appeal to the Supreme Court from the High Court of Justiciary. It's the seventh appeal in the volume 2010 of the United Kingdom Supreme Court. And if I may ask the court to go to the test as enunciated by the President, Lord Hope, paragraph 19, and it's in the bundle, my lords, at page 156. Paragraph 19, line 2. The first question is whether the material which was withheld from the defence was material which ought to have been disclosed. The test here is whether the material might have marginally weakened the Crown case or materially strengthened the case for the defence. That, of course, is Scottish jurisprudence, but it is comparable to the CPIA. Proceeding to paragraph 20, the second question is directed at the consequences of the violation. And then if I omit words and go down some 4 lines, the significance and consequences of the non-disclosure must be assessed. And then I omit words. The test that should be applied, and this is the last sentence or the last 2 lines of paragraph 20, the test that should be applied is whether, taking all the circumstances of the trial into account, there is a real possibility that the jury would have arrived at a different verdict. And then this, my lords, paragraph 24. And this is the yardstick that I ask the court to assess granting leave, and also whether the very, very narrow disposal as advocated by the respondent is truly fair. The question which lies, and I go to halfway down paragraph 24 at page 157 of the electronic bundle, the question which lies at the heart of it is one of fairness. The question which the appeal court must ask itself is whether, after taking full account of all the circumstances, and I emphasize that, full account of all the circumstances of the trial, including the non-disclosure in breach of the appellant's convention right, the jury's verdict should be allowed to stand. That question will be answered in the negative if there was a real possibility of a different outcome, if the jury might have reasonably come to a different view on the issue to which it directed its verdict if the withheld material had been disclosed to the defence. Lord Roger, at paragraph 30, makes a brief observation. It's just at the head of page 37 in the actual printed volume, saying cases like the present, an appellate court will only hold that a trial has been unfair and quash the jury's verdict as a miscarriage of justice if there is a real possibility that if the statements had been disclosed, a jury might reasonably have come to a different verdict. And then, continuing, if I may, with the late Lord Brown's observations at paragraph 35 and 36, over the page at page 159, he states this: "The trial will be adjudged unfair if, but only if, the appeal court concludes that the non-disclosure gave rise to a real risk of prejudice to the defence. This, in turn, depends upon whether the appeal court regards the non-disclosure as having denied the defence the real possibility of securing a different outcome. In short, in a case such as this, the appeal should be allowed if the court decides that had defence counsel been in a position to make use of the undisclosed statement, the jury might reasonably have come to a different conclusion, otherwise not. It is that which must decide whether the jury's verdict should be allowed to stand." And he then adumbrates the English law. This, I apprehend, would be the position of English law, both as to the test to be applied and as to the decision being one for the appeal court itself, and then cites Lord Bingham of Cornhill in the case of Bain and the Queen, a decision of Her Majesty's Privy Council as then was. A substantial miscarriage of justice will actually occur if fresh, admissible and apparently credible evidence is admitted, which the jury convicting a defendant had no opportunity to consider, but which might have led it, acting reasonably, to reach a different verdict if it had had the opportunity to consider it. Now, returning to, forgive me, my lords, returning to the issues and the question, I suppose, for the court, as to whether the court is going to adopt a narrow focus or whether leave is going to be granted to argue 2 to 5. It would greatly assist me if the court could allow me some, as it were, indication as to whether you would wish me to argue the grounds as they are and then decide leave at the end, or whether you would wish me to argue for leave now.
Well, the question of leave will inevitably be bound up with the merits of the submissions. So it's probably simplest and most convenient if you simply make all the submissions you want to make, and as you suggest, in our judgment, we will address issues of leave, and if we give leave, we'll address the substance of the argument.
Well, I'm extremely grateful to my lord. That's of great assistance to me. I will deal, therefore, now with ground one.
Right, thank you.
As the court knows, DNA evidence, considered carefully by the respondent, which was undertaken by the CCRC, building upon the work of the charity appeal that has long represented Mr Malkinson, caused it to undertake further tests, and having considered all of the tests, the respondent does not oppose this appeal. The new DNA evidence suggests that another man committed the attack, for which the appellant suffered conviction and imprisonment. The DNA evidence points strongly to the other person being the better prima facie suspect at the time. And I think it would be important now if I go briefly to the statement of reasons so that the court can have before it, although the court has, of course, carefully read all of the papers, but if I go to the statement of reasons, so that the court can see what the Commission opined, having commissioned these tests. In the core bundle, it would be tab 3, and the core bundle, tab 3, or bundle of other relevant documents at pages 76 to 77. But if I take your lordships to the core bundle, and would you be so kind as to go to paragraph 123 of the Commission's report, which, as my lord, in the case of Hamilton, has observed, can be treated as the grounds of appeal in this case. And they have, of course, as the court knows, been amplified by the grounds settled by my learned junior and myself, and also the skeleton. Paragraph 123, page 107. In analysis, the Commission notes that the judge refers specifically to the type of case where identification evidence is supported by forensic evidence. He emphasises that there is no such evidence in Mr Malkinson's case. This was true at the time of Mr Malkinson's trial. The new DNA evidence now available not only does not support the identification evidence given at trial, but it arguably undermines it significantly. The CCRC considers that if forensic evidence was capable of supporting identification evidence, it must follow that such forensic evidence in favour of the defendant's assertion that he was not the attacker and was not present at the scene of the crime conversely undermines the identification evidence. And to proceed, if we may, to paragraph 129. There is no other supporting evidence, as the trial judge in Mr Malkinson's case states. This is not a case where the identification evidence is supported, and three witnesses supports each of the other. Then the Commission observes, it appears to the Commission that had the new DNA evidence now presented been available at trial, there is a real possibility that the prosecution would not have been successful. But the Commission goes further at paragraph 130. The Commission has also considered the possibility that Mr Malkinson may not have been prosecuted at all had the new DNA evidence been available in 2003. Weighing the prosecution evidence presented at Mr Malkinson's trial against the new forensic evidence indicating the presence of another named man, the CCRC considers it not unreasonable to conclude that Mr Malkinson may not have been proceeded against at trial. Then, if we may, paragraph 145, page 111, my lords. Therefore, based on the information available to the CCRC at this time, the CCRC considers that there is a stronger prima facie case against Mr B than that which was proffered against Mr Malkinson at trial. And paragraph 151, page 112. Real possibility. Forgive me, my lords. The CCRC considers that the result of the forensic strategy described above does significant damage to the prosecution case as it was made out at trial, and makes for a compelling argument that Mr Malkinson's case meets the requirements for referral. There is a real possibility that the Court of Appeal would conclude that the conviction of Mr Malkinson is unsafe. That, as your lordships will recall, was before further forensic testing undertaken by the respondent, objected to by me at a directions hearing, how wrong I was to object to that further testing. And the result of the forensic testing by the respondent has undermined the prosecution case, we respectfully submit, even more significantly, and strengthened the merits of the appeal in a, we respectfully submit, a highly significant way. Could I ask the court to turn to the appellant's skeleton argument, please, which is Core Bundle, tab 9, and this was an attempt by us to, as it were, demonstrate to the court pictorially and diagrammatically how compelling the tests were. Because the CCRC, in testing the complainant's vest top, found the approximate location of the DNA of Mr. B. And it's in this area, and I place my hand, as your lordships can see, just above my left breast. So the vest top, or camisole, lay on top of the bra, and the bra is depicted at paragraph 8 over the page at 186, and there is a positive match, scientific analysis, a billion times more likely to be Mr. B than anyone else as part of that sample. Scientific match on that commonly found in saliva, which lies directly above the bra, and the reason why the bra is stained in blood is because her attacker virtually severed the nipple of her left breast. No teeth marks were found, but presumably biting through clothing and practically severing the nipple of her left breast. And as we state at paragraph 9, the images help to illustrate why the jury would have been entitled to conclude that Mr. B deposited his DNA on the area of potential saliva staining on the upper left front area of the complainant's vest top, while biting and nearly severing her left nipple. And then I do not need to go further than that, but then to address paragraph 10. And this is important, my lords. Paragraph 10 addresses the most recent reports of Miss Cherry, the forensic scientist who was working in conjunction with another expert performing the forensic testing of those samples which had been preserved in the forensic archive, those samples which may, as this court will determine, quash Mr Malkinson's conviction, and fortuitously those samples that were preserved over long years, because most regrettably the vest top, the bra, and other clothing, including the complainant's knickers, were destroyed by the Greater Manchester Police at one time when there was a Section 17 preservation order in place. But that is a different matter. Paragraph 10. DNA, which could have originated from Mr. B, has been detected in other areas which can be reasonably deemed crime-specific. These include in the nail clippings, scrapings from the left hand, which the complainant said she had used to cause a deep scratch on her attacker's face. Then various references are given in the appeal bundle and also the supplementary bundle of exhibits, which is marked by an asterisk before the the tab, an area of potential saliva staining on the left breast area of the complainant's fleece jacket, fabric pieces from an area of potential saliva staining on the left cup of the complainant's bra, a neck swab. The complainant was strangled by her attacker and her neck also displayed what could have been a suction mark. The inner aspects, and this is as a result of the respondent's considered and conscientious further inquiries, the inner aspects of the main body of the speculum used to facilitate the taking of internal vaginal swabs from the complainant, because obviously she bore marks of injury consistent with being vaginally raped, and also taken from the complainant's right arm, an area which she sustains puncture mark injuries. It is right to say, my lords, and we note this, that while these results have less statistical significance, the presence of DNA in multiple, arguably crime-specific locations from which Mr. B cannot be excluded as a contributor is information which, considered with the reliable attribution, and I say that as an understatement, of Mr. B as the source of the DNA on the complainant's vest top, supports the proposition that it was Mr. B, not the appellant, who was the complainant's attacker. And in fact, Ms. Cherry, in her final report, which the court is invited to receive, states that the DNA findings are within her range of expectations if Mr. B had been in contact with the complainant at some time, and that if he had had some sexual activity with her. She was an undoubted victim in this case. I'm sorry I've been referring to her as the complainant. I've been corrected.
Yeah.
The reason I'm doing that is because I'm trying very C. I'll go back to C.
Better.
So, my lords, and I'm very grateful for that correction. So, my lords, the scientific evidence has made it even stronger that it was not and could not have been the appellant. There is no need to reiterate that after the most exhaustive examinations commissioned by the Commission and also undertaken separately and independently of the Commission by the respondent, no trace of any forensic matter has ever linked the appellant to these appalling crimes. Whereas now there is testing that points to a credible, viable, alternative suspect who, at the time of these offences, lived in the locale, that his background was also local, relevant, as your lordships will know, to the issue of accent, that he had a better physical description that matched the EFIT in the opinion of the Commission, and that he had no knowledge of Miss C, nor of her partner, and vice versa. And so he had no alibi either, and that has been tested by reference to whether his passport shows that he might have been abroad, whether he might have been in hospital, or whether he might have been held, if I can put it in that way, elsewhere. So those are our submissions on ground 1. 1,000,000-to-1 vest top finding, crime specific, better fits the description of the attacker, no alibi, and lived near to the scene. were a fanciful explanation to be proffered, I don't need to go into this in detail, but the court is aware of the case of Mohammed, and I don't need to stress it in detail, but were a fanciful explanation to be proffered, there is other background evidence that could or might be deployed, and no credible possibility of an innocent explanation for these findings because of what was, on any view, a terrifying attack on the unfortunate victim, with no possibility of innocent contamination before that dreadful incident which she suffered. And then, of course, the YSTR findings. Now, the YSTR findings I've already taken the court to, but it might be helpful if I briefly ask the court to turn back to the statement of reasons before I move on to round two. And if we could go, if we may, to tab 3 of the core bundle. And I ask the court to turn to pages 113 and 114 at paragraph 160 of the Commission's report, which formed the basis of this reference. And the YSTR profile findings were undertaken at the prompting of Professors Champord and Tironi of the University of Lausanne, who suggested that together with DNA 17 testing might point to the identification of the sample known as UKM1, which was detected as far back as 2009 on the vest top, which now points to Mr. B. The YSTR profile findings are, of course, as is conceded, nowhere near as probative as the vest top finding, but the CCRC took into account the level of commonality between the UKM1 DNA profile from the vest top, now matched to Mr. B, and 5, it's now 6, of course, because of the speculum, 5 YSTR profiles which it is reported could have come from Mr. B. I'm going to omit A and C and ask the court to look at left-hand nail clippings described as very poor quality, low-level partial YSTR profile. The majority of the DNA detected in this sample could have originated from UKM1. What is important is that it could not have originated from the appellant. That is clear from Ms. Cherry's report. Then over the page to E, left nail sample, so it follows a second sample taken from the left hand, which the court may think is significant in the light of ground. Nail sample, 2 fingernail clippings, a cocktail stick used to scrape the underside of the nails, and the paper wrap, which was swab sampled. Very partial low-level YSTR results. Quotation: "It is possible to make the observation that most, if not all, of what has been detected could be explained by the presence of DNA from UKM1. And what is the significance of this? And here I allied it, as it were, with ground of appeal 2. If the court could please go back to paragraph 77 of the Commission's statement of reasons. Paragraph 77, my lords, at page 99. Additionally, further forensic work carried out in 2020 by Mr. Ken Wilson, Keith Borer Consultants, on the instructions of appeal, had confirmed the unknown male profile on the vest top and additionally identified 2 further unknown male profiles, albeit that these were YSTR profiles of very poor quality. And then I omit words left-hand nail scrapings, found on left-hand nail scrapings, although the latter could support Miss C's account that she had scratched her attacker with her left hand. So, I now proceed, if I may, to ground 2.
Well, just before you do that,
Yes,
Mr. Henry, it would help us, and it may also help with the fair and accurate reporting of the proceedings, if we could just encapsulate in 2 or 3 sentences the difference between the scientific evidence available at the time of trial and now. Because, correct me if I'm wrong, but as I understand it, all of the latest scientific evidence is taken from retained samples. The samples themselves were, of course, available at the time of trial. But again, as I understand it, the scientific techniques and capabilities as at the time of trial did not enable anyone to make the findings which can now be made in the light of scientific advances.
That is absolutely correct, my lord. There was, post-conviction, a DNA, I was going to say worldwide, nationwide DNA operation called Cube, which reviewed these cases, and by 2009, the presence of DNA not matching Mr Malkinson was found on the vest top in the area which has now been, we respectfully submit, compellingly attributed to Mr B. That was the subject of an application to the Commission at an earlier date, but the Commission, given the fact that the person was unknown, did not see fit to refer the matter to the court. In 2012, Mr B had his profile updated on the National DNA database. So in 2012, the profile on the DNA database was lodged, but it's as a result of further testing, as I have said, suggested by the charity appeal and then undertaken by the Commission, that has led to a more refined result, which results in, as I have said, the 1,000,000,000-to-1 vest top finding.
Yes, that's very helpful. Thank you very much indeed. Right, ground 2.
Ground 2. I began my submissions by referring to Fergus and the vital importance of specific weaknesses being drawn to the attention of the jury and the learned judge's duty, independently of defence counsel, to draw those specific weaknesses to the attention of the jury. A fundamental specific weakness in this case was the scratch. Now, Miss B, forgive me, Miss C claimed in her witness statement that she had inflicted a deep scratch to the face of her assailant. We know that even before she went to be examined at St Mary's, which my Lord will know is a centre of excellence for these cases, she had notified the police that she had scratched her attacker. She had, we respectfully submit, consistently stated from the outset, because that is reflected in her statement, that she had used her left hand to lash out at her attacker, and that she had drawn her hand from, on his right cheek, from his eye, or near his eye, right down to his jaw. I emphasize, deep scratch. And she believed, well, she stated, that she broke her nail in the process. Now, we naturally cannot obtain a transcript of her evidence, but we have the note of her evidence, and it has been quoted faithfully in the grounds of appeal at paragraph 77, which, my lords, is in the core bundle at tab 4 at electronic pagination 146. Clear evidence of scratching her attacker's face with her left hand and losing a nail on that hand in the process. She is recorded as telling the jury, "It was a life or death battle for survival. I managed to get my hand free. I reached up and dug my hand into the right-hand side of his face and scratched him from near his eye and cheek down towards his jaw. I did not notice my nail was broken until I was with the paramedics, though that's how the nail got broken. I told the police I had caused a deep scratch in the man's face. I broke my nail on the middle or ring finger of my left hand. At the time I had my own nails. I looked after them and they were 3 to 4 millimeters long. I have to keep them relatively short because I work in catering. I didn't know my nail was broken when I was scratching the man's face. None of the other nails are broken, and obviously it is because I had dug it into his face. I think the nail was broken when I scratched his face. I did dig my nail in, so there must have been some sort of scratch or mark, but I did not see anything. I do not recall how many nails I dug in. I was being strangled at the time. I scratched down the eye and top of the cheek downwards once only."
That's what counsel's note at trial? Or?
That is the solicitor's note of the trial, my lord. So that's the solicitor's note of the trial. Now, your lordships, the very next morning, purely as a result of a hunch, when the description of the attacker had been recited to them the night before at the scene, Police Constable Waite and Police Constable Babert, on hearing the description of the attacker, said, "That's Andrew Malkinson," because about a month before they had stopped him. He hadn't committed any offence, but he was seen riding pillion on the back of a young Mr Hardman's moped, and they'd stopped him. So, as a result of the hunch, they went to see him the following day, immediately, the day after the attack, at his place of work. And they saw that his face, both his left and his right cheek, but of course Miss C said it was the right cheek, was unblemished. That, we respectfully submit, was a formidable obstacle to this case. It was, in our respectful submission, a binary decision, because the court directed the jury, as your lordships know, as follows. And would your lordships, it's in the core bundle, tab 1, summing up, and your lordships will find it at paragraph 80. Bottom of page 20. At the end of her evidence, she said that the scratch which she thought, the learned judge uses that expression, she had inflicted was the only time she had touched him, and she said this, it was the last lash out as she was being strangled. It was the last thing she did before she became unconscious. Then this is a legal direction. It was treated as such by their lordships back in 2006 when this matter came before the court. Reference to the decision of the court then and the judgment of the court then specifically refers to it as a direction. If she may have scratched the attacker, then the person responsible for the attack cannot be the defendant. If, after examining all of the evidence, you are sure that she is mistaken on this detail, then you may safely exclude it. But notice the words I use. If and only if you are sure she is mistaken on this detail, may you safely exclude it. So this was a binary decision, a binary direction for the jury. Her evidence was a deep scratch. The day after, he was completely unblemished, and the court directed the jury that unless they were sure she was mistaken about that unequivocal evidence, they could not convict. So this was a portal to an acquittal. And we know that that defence point, that central defence point, and your lordships will know from defending in these cases, a point like that is determinative, or could be determinative. We say determinative, because that is why the direction was phrased in the way it was. And it was rationalised away. Now, I don't suggest that the learned judge was being unfair. He, noting the unchallenged medical evidence, was no doubt, I won't speculate, he was aware of the inconsistency. She says it's her left hand, but there's no broken nail on her left hand. In contradistinction, there is a broken nail on her right hand. And whilst it was his obligation, as confirmed by Turnbull and Fergus, to draw a specific weakness to the attention of the jury, confronted with that inconsistency, as it seemed in the complainant's own account, because of course the doctor is presumed to have got it right, the learned judge posed these questions, and we go back to the summing up. I take it as read, paragraph 78. Well, in fact, actually, in view of the importance of this, I will ask the court to go back to the summing up at page 20, paragraph 78. Miss C told you that at some stage she managed to get her hand free, and she believed, undoubtedly believed, that she scratched his face on the right-hand side from the cheek to the tip of the jaw. The defence emphasised that the defendant had no trace of any such injury. Did she succeed in scratching his face in the way that she clearly believed she did? In the aftermath of this incident, when she was being examined by the paramedics, it was noticed she had lost a fingernail. That is what she told you. And she said it was from her left hand, she thinks. And she held her hand out in front of her in the witness box. It was the middle finger. Paragraph 79. She said at the end of her evidence in response to a question I asked that she was right-handed. Later, you heard evidence from a doctor read to you that the fingernail that was missing was from the middle finger of the right hand. What does this tell you of her memory of this particular detail? Does she really remember scratching the right-hand side of the face of her attacker with her left hand. Now, I realise that there are subsidiary matters that the respondent relies on, which I've already read to the court at paragraph 80, but that is the major, the overwhelming basis for why the learned judge felt consistent with his public duty and the overriding objective, though I don't believe the overriding objective had then been, as it were, launched onto the criminal justice system, that he had to deal fairly with both the prosecution and the defence. And so, therefore, he drew that anomaly to the attention of the jury. But it negatived. And I can say that with absolute force because the appellant was convicted. It negatived and demolished a reasonable prospect, a reasonable possibility of acquittal. We now know, they having been, as it were, concealed, withheld, undisclosed, however one describes it, we now know that for 15 years post the appellant's conviction, there were photographs in existence taken on the very night of the examination, when she was examined in the early hours of the morning by the doctor, that shows that her fingernail on her right hand, the middle fingernail, was not broken. Whereas, as the respondent concedes, the fingernail of her left middle finger is shorter. We submit considerably shorter than the others. And so this suggests, well, in fact, it does more than suggest, it shows incontrovertibly that the medical evidence read unchallenged to the jury was wrong. And it was upon that foundation that the learned judge postulated those questions. And those questions resounded, as they must have done in the jury, because we know, as your lordships will have read, that it was the second question, because there are 3 lots of questions sent by the jury, but it was the second question that the jury asked. They asked to be reminded of the scratch. No one can be in any doubt of the fundamental importance of that issue. It was, as I have already submitted, a binary path for the jury. If Miss C may have scratched, the learned judge correctly deals with the burden. If Miss C may have scratched the defendant, then Mr Malkinson cannot be found guilty. Only if the jury is sure that Miss C did not scratch the attacker may they then exclude the evidence of her recollection and with it demolish the best, perhaps really, when one analyses this case, the only really strong defence point. And so, being guided by the authorities of the Supreme Court in McInnes and the Lord Advocate, in Garland, in Acamo, the real possibility test, the duty of decision which lies with your lordships and your lordships alone. How can it be said that this would not? How can the respondents submit that this would not have given rise to a real possibility of acquittal? In fact, we go further.
Mr Henry, we've looked at the photographs,
Yes.
which were found, the unused photographs that weren't disclosed.
Yes.
From our perusal of the photographs, we can't see any photograph of the left hand. But there are photographs of the right arm to show an injury, presumably.
Yes.
And there is an undamaged nail on the middle finger of the right hand.
That is correct. believe the respondent has made a concession about this. The reason why this photograph of the right arm was taken, and I mimic the pose, is because of the injuries to the inner aspect of the forearm. But, and this is rather like that Bruegel painting, the Fall of Icarus, where it may be titled that, but it's really at the edge of the picture. You can see here her left hand supporting the humerus, the upper arm of, and it's clear from that one can discern that the middle finger is shorter, consistent with her account, and now buttressed and supported by the YSTR profiling. Yes, my learned junior, maybe that when your lordships look at them again, apart from seeing, you can see how long the nails are there.
Right.
But you can also see how short that nail is there, which is the middle finger of the left hand. You can see that there is no keratin, no fingernail, as it were, rises prominent above that, I mean no disrespect, that digit.
Which photograph number is that, so we can just...
That is photograph number 28.
It's the penultimate.
It's the penultimate photograph. Paragraph 28.
I suppose you would say that even if it was just showing that the right middle fingernail was intact, would be enough to contradict the doctor. I'm thinking it through. What would defence counsel have done with the photographs? Let's just see how it would work.
Defence counsel, Mr Samuel, said he would have pursued this matter with vigour had he been aware of it. Not only would he have been able to show by the clear evidence that none of the fingernails on the right hand were broken, so he could have pointed by the via negativa that therefore it must be the left, but he also had, peeking above that, the fact that I bite my nails so it's easy to show, there is no fingernail protruding above there. And then one has to ask the question, why were, in contradistinction to the right hand, why were there scrapings and cuttings taken of the left hand? It indicates that she was telling the paramedics and the doctor that she had used her left hand, and of course the YSTR profiling to some extent supports that. But this is a fact that cannot be changed. But unfortunately, because of material non-disclosure, it was changed to the defendant's detriment.
Can I ask a question?
To the appellant's detriment.
Can I ask a question?
Yes.
Can we assume for a moment that it had been disclosed, and so therefore in the armoury, as it were, of the defence, the mistake about the hand would have been there? The judge's direction would have been just the same, wouldn't it? It would only be if they were sure that the victim did not mark the face of the attacker that they could convict the appellant. So therefore they would have to discount the fact she said that I marked the face of the attacker in order to convict.
But that, and I mean no disrespect to my lord, there is an element of hindsight there, because what would be the factual foundation for, as it were, questioning her account? The prosecution could not cross-examine her. They had to accept that she said left hand, left fingernail broken, deep scratch. Maloney, friend of the respondent, says that the the Commission has overstated the importance of this matter. In fact, actually, if we go to the statement of reasons, and if I may ask you I do ask you very briefly, my lords, to go to page 114 and paragraph 165, forgive me, 164. This is what the Commission said. This is significant because the trial judge raised the question of whether the victim was mistaken about having scratched her attacker at all, and told the jury that if she may have scratched her attacker, then the person responsible for the attack cannot be the defendant. Dr. Anderson's mistake allowed the judge to suggest that the victim may have been mistaken in her account of scratching her attacker. This undermined an important defence point made by Mr Malkinson's counsel at trial, that the fact that Mr Malkinson was not injured or disfigured in any way when he was seen by the police on the 25th of July, 6 days after the attack, meant that he could not have been the attacker. With the greatest respect to my learned friend, but also to the Commission got that wrong. It's the very next day. What basis, we respectfully submit, would there have been to doubt her account? The defence were not going to doubt her account. The prosecution could not cross-examine her on her account. The learned judge, as I've already said, consistent with his public duty, felt on what appeared to be the irrefutable and correct evidence of the doctor that it was important that the jury should consider the whole picture. But for that, we respectfully submit, the learned judge would have been faced with a submission of no case to answer at half-time.
The judge was prompted to give the direction because of the apparent confusion between the hands.
Yes.
That she may have been mistaken about the hands.
Yes.
And then went on to make clear that only if you're sure that she did not mark the face of the attacker could you convict the appellant. So that may be the reason why he actually made that comment.
Yes.
But that would still have been a direction necessary, assuming the trial was at the point for the jury to be retiring, so gone past half-time. That would have been a direction necessary in any event, because it was quite clear that he did not have a mark to his face. So therefore, the judge would have to have directed the jury, if you're to convict him, you have to be sure that she didn't mark him.
I'm not complaining about what the learned judge addressed, my lord. But what I am suggesting is that the evidence that prompted it was mistaken, and that had disclosure been made, it could have been utilised to very, very considerable effect to not only suggest that she was right and the doctor was wrong, but if it had been disclosed, then the doctor would have been called. The doctor would have obviously had to have admitted to her error. And then defence counsel could have said, and of course, the nail could have been broken, could it not, in inflicting a deep scratch, to which the doctor inevitably would have said, yes, that's possible. So the whole course of the trial was distorted by material non-disclosure. And in a case of identification, where it falls into the fleeting encounter category, and so far as the victim was concerned, a longer identification, but in the most profound and difficult circumstances, this was radically inconsistent with guilt, and it was the very strongest evidence of innocence. So, is it really to be said that, oh well, she was just about to pass out, maybe she's wrong about that? The principal basis was most regrettable evidential error, compounded by non-disclosure, which prevented that error being detected and corrected, which would have allowed the defence to amplify the point at trial. These are the pernicious consequences of non-disclosure. it would have allowed the defence to develop the point even more strongly. And my Lord, Mr. Justice Spencer's point I adopt as well. It's the belt and bracelets. I could use, for example, the fact that none of the fingernails on her right hand were broken, which would be unanswerable so far as the doctor's error was concerned, but also the left middle finger peeking over her upper arm, photograph 28 in the bundle. So far as round 2 is concerned, being guided by the principles in the Supreme Court case of McInnes, Garland and Akame, this surely would have created a real possibility. It was one of the matters, of course, that was raised in the first appeal as well. And so a continuing denial of disclosure meant that that issue, which focused in the 2006 appeal, is another lamentable part of this most unfortunate story.
Mr. Henry, it's obviously it's easy to speak with the benefit of hindsight, but it's a bit of a puzzle. It's a bit of a puzzle to me, at any rate, how at trial the situation obtained that you had a witness saying, "I broke a fingernail on my left hand," and agreed medical evidence saying there was a broken nail on the right hand. And on the face of it, not much investigation of that.
Yes.
Have you been able to shed in, I mean, it may just be that it was a collective oversight, but have you been able to shed any light on that?
No, I can only shed light on the Obviously, it was relied upon. So far as the investigation of the issue is concerned, there really can be no fault attached to those who then represented the appellant in my respectful submission, because these photographs were not scheduled. They weren't scheduled. They, as far as anybody else was concerned, including the prosecution, they did not exist until Mr. Burley, who is present before your lordships, was allowed to look at a box in 2019 and found these photographs, which undoubtedly relate to this case, but which hitherto had absolutely no provenance at all. Neither the statement of the photographer who took them, nor their existence was ever committed to paper. And
Well, I'm just looking at the witness statement from the crime scene investigator, it's tab 72 of the main bundle.
yes,
It's dated the 20th of August 2003. So that's before the trial. Whether it was disclosed as unused material, we don't know. But that does reveal that there were two
yes,
separate visits to take photographs. One on the afternoon of the 19th of July, and the other 4 days later on the 23rd of July. So the ones that you're asking us to look at were the first of those.
Yes.
On the 19th.
that is correct.
But are we to understand that there were some photographs which were seen, either served or disclosed? The other bundle?
Yes, the other bundle. And that's referred to by the learned judge in the summing up. And he specifically identifies them because they are the facial photographs that show the marks of profound injury to the victim's face. and other photographs which do not include the photographs that we rely upon and seek the court's leave to admit in these proceedings.
But if those photographs, that bundle of photographs was part of the evidence, one would have thought that the statement of Matt's
evidence that they were, and the whole conduct of the trial suggests they weren't. We have the unequivocal recollection of Mr Samuels that they were not, and that the issue would have been pursued with vigour. But also, it is inconceivable that the learned judge would have postulated the questions he did had those photographs been disclosed.
Yes, I'm not suggesting they were disclosed. I'm querying whether the album that was known about at the time, which was in evidence, could have been in evidence without the witness statement.
I'm afraid I can't answer that question, my lord. I can only say that we only received
May not have been.
so it may not have been disclosed. And in fact, we respectfully submit that it could not have been disclosed because, obviously, responsible counsel on both sides would not have allowed the jury to resolve an issue on erroneous evidence. Erroneous evidence which is now incontestably proved by the photographs. And similarly, it's inconceivable that the learned judge would have posed those questions in the way he did had he been aware of those photographs. So, for all of those reasons, we respectfully submit that that unbalanced the trial on a determinative issue. Unless there are any further questions that the court would wish me to address now, I propose to move on to Ground of Appeal 3.
Thank you.
So, Ground of Appeal 3, I'm not trying to concertina these, my lords, but grounds 3, 4 and 5 have, to borrow that expression, commonality. The respondent submits that Mr Seward and that although their reliability is in question and now obviously undermined by the fresh scientific evidence, their integrity is not. We submit the following. They were purportedly independent witnesses who voluntarily came forward to assist the police in their inquiries, and they were treated as supporting witnesses who could have corroborated and did corroborate the identification by Miss C. Independence raises a very interesting question in this case, and I'm not asking the court to sit as a court or a tribunal of inquiry. I'm asking the court to look at, as it must, on what the defence could have done with the following information, which was not disclosed and which might indeed have profoundly undermined the suggestion that they were independent at all. And when I use the term they, there is no doubt that they were welded together. They were partners. But I refer, of course, to Mr. Seward's involvement with the authorities during the time, in fact, the entire currency of his status as a potential witness and actual witness in this case. On the day he came forward, ostensibly to assist, he presented himself, and it is clear from the evidence of a police officer, Carson, who was manning a mobile police station that was set up in the vicinity of the incident that had taken place about a week before, that Mr. Seward and Miss Craig presented themselves at that mobile police station and tendered the possibility that they might be able to assist. What was not known was on that very day, Mr. Seward had been arrested for driving offences. Arrested on the day he ostensibly came forward to assist, and again arrested on the day that he made a purported identification 6 months later, on the 14th of January 2004, little more than a week before the trial. If I could ask the court to go to the court bundle and to the chronology or timeline. And your lordships will find it at tab 8 of the bundle. And we respectfully submit, and we'll never know the truth about this, obviously, because of such an effluxion of time, and also because the unfortunate Mr. Seward, a long-term heroin addict, is now dead. But there is, even on this chronology, enough to suggest that he was not independent and that he might have fallen into the category of witness as considered by the court in Kelly, who felt under, if not pressure, but under some sort of incentive that they might, as it were, improve their own position if they were going to be helpful and assist the police. We know that on the 2nd of May he was arrested, page 180, my lords, for driving while disqualified. He was later that same day charged for both disqualified driving and using a vehicle without insurance. We don't know the outcome of that. He was then arrested on the 21st of June after he'd been seen on CCTV using an unknown substance, which was later, he admitted to being amphetamine. But then, of critical importance, if my lords would please go to page 181. 26th of July 2003, arrested for driving without a licence. We note, of course, that in May it had been for driving whilst disqualified, but arrested for driving without a licence, without insurance, and without a valid MOT. The stop takes place on Long Causeway, Farnworth, just 1 mile from the mobile police station, placed at the crime scene. The available records do not state whether Beverly Craig was with Mr. Seward when this stop took place. But then we have the next entry at 1:16, and then we can see that in the middle of nowhere, as it were, Long Causeway, Farnworth, I hope I'm not being unkind, but I think it's in the vicinity of the motorway and various articular roads. At 1:16 in the morning, Beverly Craig and Mr. Seward, with the latter driving, come forward as witnesses at a mobile police station set up at the crime scene. Those charges are hanging over him throughout the rest of this period. We know that on the 23rd of August, a witness statement was obtained from him, the 23rd of August, entry 23rd of August at page 182. We know that on the 13th of October, he was cautioned for possession of amphetamine and heroin. Whether that is lenient or not, what is important is that he was actively abusing drugs, and he is an identifying witness. We then know that on the 14th of November there are a series of his failing to attend hearings, what might be commonly described as him being a bit of a bail bandit. 14th of November, fails to attend hearing at Bolton Magistrates Court regarding his 26th of July driving offences. Convicted in absence, 6 driving offences. 2nd of December, arrested pursuant to a warrant by Salford, so not Bolton, so it follows that some other wrongdoing. 10th of December, fails to attend a hearing at Bolton. That must refer back to the 26th of July driving offences. 17th of December, in tandem, fails to appear yet again at Salford. Again, not clear what those proceedings relate to. 14th of January, arrested for failure to appear at Salford. Handed over to G4S, appears at Bolton Magistrates Court regarding his 26th of July driving offences. So, arrest on the day he comes forward, they're hanging over him, and he's arrested yet again on the 14th of January when he makes an identification. But note he's remanded to reappear on the 29th of January. And then after his arrest and court appearance and while on court bail, he takes part in a video identification procedure nearly 6 months after his purported fleeting sightings, picking out the appellant, which he says he's 100% sure and in no doubt. And then the 29th of January, well, the court has read this, but he appears again before Bolton Magistrates Court. His convictions, proved in absence for 2 driving offences, are set aside and the charge is withdrawn. A charge for failing to appear is also withdrawn, and in total he's fined £145 and ordered to pay £42 in costs in relation to his remaining convictions for 4 driving offences and a failure to surrender offence. A curious feature of that, apart from the fact that these matters were proved in absence and that he was an incorrigible absentee, is that he was convicted of no insurance. And he could not have been insured because we know that he was arrested for driving whilst disqualified. We know that he was arrested for driving without a licence. But the no insurance conviction was withdrawn and the conviction set aside, and he was allowed to plead instead to failing to produce an insurance certificate, which is, as it were, a less serious offence. I'm not saying that they are that no insurance is in the highest canon of criminal offending, but it is something. You are not insured, you cannot be insured, and yet you are allowed to plead instead, your conviction being set aside, charges withdrawn, to failing to produce an insurance certificate, when of course everybody knows that you could not have had an insurance certificate in the first place. It's less than a week after the 29th of January that he gives evidence against the appellant. And we respectfully submit that that would have been devastating, such disclosure, to any suggestion that he was independent. You know the case of Kelly. If I may briefly take you to it. It's tab 8 in the authorities bundle, and it's before Lord Justice Pitchford, Mr Justice Walker and Mr Justice Cranston. And the facts are immaterial, but what was important, in contradistinction to this, where there were offences and were charges, actual charges overhanging, was that the key witness in this case, Miss Nugent, was facing the potential of fraud charges, but she had not been charged. The court stated, although they dismissed the appeal on other grounds, that the defence ought to have been allowed to cross-examine her on that. The court's reasoning is at paragraph 62. The purpose of the admission of the evidence would have been, Miss Queen's counsel explained, not to establish Miss Nugent's bad character, but to establish that the witness feared she might be charged with fraud offences. The accusations under investigation were, it would have been suggested, an incentive for the witness falsely to implicate the appellant, etc., etc. We are prepared to accept, by a narrow margin, that the judge would have permitted cross-examination of Miss Nugent on the subject of her own position as a suspect in fraud. And then, having established the breach, they had to look at the consequences. In this case, the consequences would have been able to cast a pall, and it wouldn't have been Munthray, would have been able to cast a pall on Mr. Seward's involvement. You might allow one coincidence, and I'm not going to trivialise this by stating the Lady Bracknell point, but you might allow one coincidence of being arrested on the day he purportedly comes forward to assist, but to be arrested on the day that an identification is made, and then for, after that identification is made, another appearance in court where matters proved in absence, no doubt a convincing excuse is proffered, and so therefore they're withdrawn, and he's allowed to plead to lesser offences. But in short, 14 criminal offences during the currency of a 6-month period, with a lenient disposal very shortly before he's about to give evidence in this case.
Are you including in the 14 the ones of which he was not convicted?
Yes, because they are in some way finessed, because unfortunately we don't know.
They're accusations.
They are accusations, but obviously we are compromised by two things. First of all, the affluction of time, but secondly, the fact that it has been accepted by the Greater Manchester Police that there has been some rationalisation of his police national computer entries, and that certain offences have been weeded. Some, no doubt, would have been non-recordable. Some, we suggest, were recordable, but no longer appear on his record of his PNC record. And if the court requires further elaboration of that, I do crave the court's permission to address you on that a little bit later, because that level of granular detail, I'm afraid, at this moment is beyond me, though not, of course, beyond my learned junior. But those are our submissions in respect of that. But then one has to look at the convictions such as were known themselves, which were only disclosed, again, as a result of a chance discovery by Mr. Burley, who had earlier discovered the photographs. And one notes that in contradistinction to somewhat peripheral witnesses, the Hardmans, and the Hardmans, you'll see their evidence. It begins at page 39 of the summing up, Core Bundle tab 1, paragraph 159. They were both cross-examined on their previous convictions. They were essentially witnesses as to characteristics of the appellant, but they were cross-examined as to their previous convictions, and that's referred to at paragraphs 168 and 174 of the summing up at pages 40 to 41. In contradistinction to the Hardmans, where their previous convictions were scheduled on the NG6C, the Schedule of Non-Sensitive Unused Material, and where their personal descriptive forms that revealed their previous convictions were also scheduled on the NG6C, there was nothing to suggest that either Ms. Craig nor Mr. Seward had previous convictions. Nothing was scheduled. An explicit request was made, as is clear from the chronology, for the records of previous convictions from all civilian witnesses. And of course, faced with the provision of previous convictions in respect of the Hardmans and the absence of previous convictions, everybody, and I do not criticise Learned Prosecution Counsel either, nor the Crown Prosecution Service who instructed him, but nobody was aware that Mr. Seward and Miss Craig had previous convictions. Nobody was aware. And so therefore you have the concession made by the defence that all of the witnesses were honest. And that was a matter that was mentioned by the learned judge. If your lordships would please go to the summing up. One can see, give me a moment. So I have to correct something, my lords, and it's important I do so immediately. The Hardmans' previous convictions were not scheduled. I do apologise for my error, but they were disclosed in response to a written request. Not, however, of course, Miss Craig nor Mr. Seward. You have, and again, there's no objection taken to this. Paragraph 7. You must decide in relation to the witnesses which witnesses are reliable and which are not. You come to your own judgment about them. It's a useful test to ask yourself two questions about a witness. This is not a legal direction, the learned judge stresses. It's common sense. Ask yourselves firstly, is the witness honest? Secondly, is the witness accurate? If you can answer yes to both those questions, then the witness must be reliable. So ask yourselves that in relation to the witnesses you have heard. And then the following at paragraph 17. A witness who is convinced in their own mind may as a result be a convincing witness. This is at page 6, my lords. But nevertheless may be mistaken, and this may apply to a number of witnesses. In this case, the defence say that all three witnesses that I have named are all honest. It's not suggested they're telling lies, but it is said they are all mistaken, and a witness who is honestly mistaken can be a convincing witness. Well, that concession would not have been made, and particularly given what we know about the interaction between Mr. Seward and the police, one would have looked with great care and scrutiny at how those witnesses, Miss Craig and Seward, came to be involved in this case. Now, if I could deal with it, please, in this way. Let us address first, forgive me, paragraph 26 of the summing up, I'm being told. I hope your lordships will forgive this double act that is unfolding before you.
Certainly.
I find it very helpful, and I'm very grateful for any assistance I'm given. paragraph 26 of the summing up. Yes, again, I'm most grateful. However, the evidence of Miss C, page 8, my lords, is capable of being supported by the evidence of both Beverly Craig and Michael Seward in the following manner. If you decide that those witnesses are honest, then you have here 3 honest witnesses of whom it is alleged they have all made the same mistake. And if you decide that, you may think, and it's a matter for you, that it is common sense that 3 honest witnesses do not all tend to make the same mistake, providing that you are sure of the following matters. And again, no complaint as to what the learned judge did, because he put, provided you are sure of the following matters. Because it might be thought that that undermines Turnbull, that a number of honest witnesses who truly convince themselves can be mistaken, but the learned judge properly then goes on to the other matters, in particular paragraph 29, which is utterly unexceptionable, and no complaint is taken with the summing up. But the summing up was predicated, and the twin pillars of assessing reliability was again predicated on material non-disclosure. Another concession by the defence, paragraph 28. It appears from submissions this morning that the defence concede that the police did carry out the procedures correctly. Well, of course, identification procedures aren't just a one-way street. It's a bilateral relationship between the police and the witnesses. And again, disclosure could have caused the defence to look at all of the circumstances surrounding that in even greater detail than they did. But what does it come to? The court, in previous cases, which are not illustrative for their facts but for principle, have taken a robust line where there is material non-disclosure of the previous convictions of witnesses. It's a fact-specific exercise. If there's absolutely no challenge to those witnesses at all, then obviously the point would not carry water. But here, there was ample material that the defence could have used to undermine the reliability and credibility of both Miss Craig and Miss Seeley. Now, dealing with credibility and reliability, they are inextricably entwined. And we know that from distinguished authority of this court by none other than the Lord Chief Justice himself, Lord Parker, in the case of Parks. Your Lordships will find that at tab 15 of the electronic bundle, starting at page 194. And if I take the court to it, at the trial, page 194, and this is from the headnote, the only issue was that of identity. The prosecutrix had previous convictions of dishonesty, which at that time were unknown to the defence. The test was then, for material non-disclosure, are addressed by the Lord Chief Justice at the foot of page 195 of the bundle. Those principles can be summarised in this way. First, the evidence that is sought to call must be evidence which was not available at the trial. Tick. Secondly, and this goes without saying, it must be evidence relevant to the issues. Again, we respectfully submit that is engaged. Thirdly, it must be evidence which is credible evidence in the sense that it is well capable of belief. Well, that cannot be disputed. And then it is not for this court to decide whether it is to be believed or not, but evidence which is capable of belief. Fourthly, the court will, after considering that evidence, go on to consider whether there might have been a reasonable doubt in the minds of the jury as to the guilt of the appellant if that evidence had been given together with the other evidence at the trial. And in citing that, I'm not seeking in any way to go behind the statement of the justices of the Supreme Court in McInnes and the Lord Advocate. And then if I could ask the court to go to the next paragraph. Forgive me, I'm just reading the next paragraph, and it's clear there, in contradistinction we respectfully submit to this case, that no possible criticism can be made of the police for not informing the defence at the time of the trial of these convictions. May I interpose there? The Commission have postulated that these previous convictions could have made their way into the hands of the defence, could have made their way into the hands of the prosecution before trial. The Commission says it can't conclusively prove that they were not. Well, how could one expect the Commission to conclusively prove a negative after a period of nearly 20 years? What we do know is that responsible prosecution counsel described Miss Craig as honest in his final address to the jury, which I very much doubt he would have prayed in aid her character had he been aware. And also, the defence would have not made this concession. The trial proceeded on the basis that these were witnesses with no stain on their character, civic-minded, coming forward to do their duty. Returning to Parks, the next paragraph, which begins, the second question is whether it was relevant. I omit words. The court has felt very great doubt whether these convictions were really relevant to that issue. But then these words. No one has suggested that she knew of the appellant before, that she had any grievance against him or against his family, or that she had any dishonest motive for identifying him. Accordingly, it might well be said that her dishonesty in the past, and incidentally her last conviction in 1954, was utterly irrelevant to the question of identification. It can, however, be put rather differently, namely in this way, that the complainant admittedly did not have any great opportunity of identifying her assailant, but that applies with great force to Miss Craig and Mr Seward. Her answers were not always quite consistent on the point. That applies, and I will take the court to it, to both Miss Craig and Mr Seward. And it can be put, and indeed Mr Clay, who was representing the appellant, has put it in this way, that although she may at one time have thought quite honestly that the appellant was her assailant, yet being a dishonest person, she was not so prone to be frank with the court, and that the not so prone to be frank with the court. I'm so sorry, my lords. May I just? I'm afraid that sometimes when one highlights things, one makes it opaque.
Highlighted to the state of illegibility.
Forgive me, my lord. You can see it clearly.
No, I'm saying that your highlighting has rendered it illegible.
Yes, exactly. Oh, that's much better. Thank you. No, it's not. Forgive me, my lords. I don't mean to become a double act here and a comedy. I think that Mr Hardy, though, would be definitely Stan Laurel to my Hardy. I'm so grateful to my learned junior. You've got it here. Yeah, I'm very, very grateful. Her answers were not always quite consistent on the point, and it can be put, and indeed Mr Clay has put it in this way, that albeit she may at one time have thought quite honestly that the appellant was her assailant, yet being a dishonest person, she was not so prone to be frank with the court and would not retreat from her allegation that the appellant was her assailant, even if she were satisfied in her own mind that he was not. I'm very, very grateful to my learned junior. The court then continues. It is emphasised that this was a case of no corroboration of a young man with a perfectly good character on the one side and a complainant who has 8 convictions for dishonesty on the other side, and who was referred to by the chairman in the course of his summing up as an honest and truthful witness. The court has had considerable doubt on this matter, but they have come to the conclusion that in the present case, these convictions were just relevant, and if they were just relevant, then they might have had an effect on the minds of any jury, properly directing their minds to the matter. Accordingly, the court allowed Mrs. Milton, the complainant, to be called, and she quite frankly admitted those convictions. And then over the page, and this is, of course, before the landmark decision in Turnbull and the Devlin report, these questions of identification, it is well known, are difficult. They can lead to a miscarriage of justice, and the court, though with great hesitation, has come to the conclusion that it would be unsafe to allow this conviction to stand, and that if the evidence to which I have referred to had been given at trial, it is impossible to say that the jury might not have had a reasonable doubt in this matter. So, the point is also addressed if the court thinks that this is somewhat antique, because it's about 62 years ago, but it has not been disputed or doubted by other constitutions of this court. It is, and I know that the court will be familiar with the phrase that I've used, a strong court, the Lord Chief Justice and Mr. Justice Slade, among others. But if there is any doubt about the principle, although it wasn't cited in the case of Akame, there is at paragraph 33 of Akame the following. And this is page 8 of the bundle, my lords. In our judgment, Mr. Hughes' submissions take too narrow a view of the potential significance of Mr. Santos' conviction and his lies to the police. Whilst it is correct that it was not Akame's case at trial that Mr. Santos' purported identification of him was dishonest, it was his case that Mr. Santos' evidence was dubious and unsatisfactory in the respects we have identified. It seems to us that the bad character evidence now available, had it been before the jury, not only would have enabled counsel to cross-examine him on the basis that he might be lying about his purported identification, but to advance a submission to the jury that his previous conviction and lies to the police, taken with the other matters which we have already identified, made his evidence of identification all the more unreliable. And so, therefore, it goes, as the court therein opined, to credibility as well. Now, let us look, it's entirely a matter for your lordships. I see it's 10 to 1, and I have been on my feet solidly since 10:30. I'm about to go launch into, as it were, an analysis of Miss Craig and Mr. Seward. If the court would wish me to continue now, of course I will, but that would be, for my purposes, if I, and I mean no disrespect or impertinence to the court, a good time to stop if the court pleases.
Need to make use of the time, Mr. Henry, and continue. I think we need to make use of the time and continue.
Certainly, my lords, of course. Dealing with Miss Craig. Miss Craig made an identification of the wrong person in the identification suite. She's then reported, and she never made a statement to this effect, and your lordships will have gathered that from an exchange between Mr. Samuels and the learned trial judge when the jury asked for her statement to Mr. Twiss, and Mr. Samuels' trial counsel tried to get the judge to tell the jury, well, she never made a statement about this, because in fact she was never asked to confirm that she made an error, and but then gave the correct number in a subsequent Section 9 statement. It's all based upon her reported conversation to a Mr. Forgive me, I mean no disrespect, to a police constable, Mr. Twiss. And it seems that the cross-examination on this point dwelt more not on what she said so much as to where the conversation allegedly took place, whether it was in the corridor or whether it was outside. She maintained that she had made a mistake and had corrected it to him, however, when she gave evidence on oath. But again, that evidence was, as it were, delivered from the witness box without the matter being reduced to a statement. She was remarkably emphatic on this point. And if I could ask the court to go to the summing up. And this, of course, was repeated twice because the learned judge had to repeat most of his summing up pursuant to the questions of the jury after they had been in retirement for just over a day. Bottom of page 32, paragraph 131. Beverly Craig was questioned closely about the identification procedure. She agreed that initially she had been sure it was number one, that he was the man who had been watching her as they turned the corner, but she said she changed her mind. She said she did not think she could go back into the room once she had come out of it. She was trying to convey the quandary that she felt she was in. She did not think that she would be allowed to see it all again, but she was sure she had picked out the wrong man. She was certain it was number 4, but his hair was shorter than when she had seen him. Well, this is another specific weakness which didn't perhaps get the emphasis that it deserved, but it was the defendant's case that he had not cut his hair for some considerable time. The witnesses, Mr. Seward and Miss Craig, had said, together with the the victim, that the hair was wavy on the top at certain times. There were inconsistencies. But she said she was certain it was number 4, but his hair was shorter than when she had seen him. A photograph of the appellant, taken at the request of the police by his employer, shows that he has got about 2-inch hair. You will have seen the photographs, my lords. She was asked by Mr. Samuels whether she could not have made a mistake in saying it was number 4. And she said the only mistake she made was in not picking him out in the first place, or forgive me, not picking him out first, and that she was certain she was not mistaken. Now that is classic, we respectfully submit, Parks territory. Classic Parks territory because it would have allowed Mr. Samuel to say, are you being completely truthful about this? Are you absolutely sure about this? Are you being truthful about this? It would have allowed that line of cross-examination. The same applies to Mr. Seward. If we go to page 38 of the summing up in paragraph 153, when asked if he was identifying the man he had seen on the street or the image he had seen on the e-fit, he said he had picked out the person he had seen, and he said he was in absolutely no doubt whatsoever. The defendant, of course, was at number 6 on that parade. And that is repeated again later on in the summing up of paragraph 310. And here we have a man who, fleeting glimpse, in his witness statement, he is talking about somebody who is 35 to 38, but when he is giving evidence, he says, from a fleeting glimpse of 2 or 3 seconds from 100 meters away, the man appeared to be 38. Mr Malkinson was 38. And again, if his enmeshment with the police, as demonstrated in the chronology that I have taken the court to, had been put before the defence, that could have led to the exploration of contamination. And it was not. Now, these are not fanciful, armchair general observations by me, I respectfully submit. It is recognised that the force of previous convictions in undermining credibility and confrontation is a fundamental right to be able to cross-examine witnesses in the most powerful way possible. And I don't go to it for the facts, but simply as a statement of the principle. And if the court, please, would be so kind as to go to Kenneth Charles Smith, paragraph, forgive me, at 19 of the authorities bundle. Sure your lordship will remember His Honour Judge Myerson, but here we had it, tab 19, at page 226, Lord Justice Hutchinson, Mr Justice Scott Baker, and this was a case of unlawful importation, evading the prohibition. The dilemma of defence counsel was set out by Mr Bourne at page 231 of the bundle. This was, I think her name was Mrs Bruce. Yes, it was Mrs Bruce. Mrs Bruce, last paragraph on that page, she was cross-examined, and we have been told by counsel for the appellant, Mr Bourne, that he felt it necessary to cross-examine with a certain degree of circumspection because he was presented with a lady who appeared to be a respectable middle-aged woman of good character, giving evidence which was not motivated by self-interest and which in some respects implicated her own husband in these offences. One can understand why he was so cautious in putting suggestions that he had to put in order to in order to adequately put the appellant's case to the witness. Could your lordships please go to page 236. Subsequent to the trial, it seems as a result of some inquiries made in the first instance by the solicitors acting for the appellant, it was discovered that Mrs Bruce was not a person of good character. Unnecessary to go into the details, suffice to say that it was discovered by customs investigators acting on information contained in a marriage certificate sent to them by the appellant's solicitor that Mrs Bruce had previously gone under a different married name and that her maiden name had been Swainston, but she had at some time used the name of Painter. Inquiries disclosed convictions against her in one or other of those names to the following effect: 1967, 21, robbery with violence, imprisonment 18 months, 73, abstracting electricity and assault, fine subjected to suspended prison sentence, 74, 4 offences of criminal deception, conditionally discharged, and most importantly, given its date, 1991, for 8 offences of obtaining property by deception. She'd received a total of 15 months imprisonment, suspended for 2 years. There was therefore plainly ample material to undermine her credit and to suggest that she was somebody whose evidence was not worthy of belief. The failure to disclose them and the disadvantage under which the defence, forgive me, my lords, I'm going to the last 4 lines of page 237. The failure to disclose them and the disadvantage under which the defence as a result laboured constitutes the third of 3 grounds which are advanced in support of this appeal. We've heard argument from Mr Bourne only on that ground, and having heard the concise and restrained reply of Mr Amor, we felt it unnecessary to trouble Mr Bourne to develop his other grounds of appeal about which we say nothing more. But then there is, however, an exegesis of the duty of the Crown to disclose previous convictions. Again, I interpose the argument here, the strong submission, that it is no use saying it can't be proved that they weren't disclosed. The whole trial was conducted as if they were not, and the Commission was prepared to accept that they were not. And unless it is recorded and unless it is documented, we respectfully submit, then we would be driving a coach and horses through the CPIA, but also the Commission could never establish whether something had not been disclosed, and it would be impossible to unfalsify the assumption that things had been disclosed but perhaps had not been recorded. So therefore it is important, I respectfully submit, that we keep our feet on the ground. There's an exegesis, however, of the law as to the importance of disclosure of previous convictions, and then these words, which I adopt, and I will explain why after the short adjournment. Had the defence, and this is page 240, my lords, just above the half marker, had the defence been in possession, had they been in possession of those convictions, they would have been able to cross-examine her in a much more robust and effective way than in the event they were. Though the defendant would still have faced substantial difficulties, we are quite satisfied that the absence of the information about Mrs. Bruce's convictions substantially handicapped the defence and made it much more difficult for them effectively to deploy the defendant's case. In those circumstances, we have to ask ourselves whether his conviction is unsafe. It will come as no surprise in the light of what we have said to learn that we conclude without hesitation that it is not a safe conviction, and accordingly the appeal must be allowed. And, my lords, would that be a convenient moment?
Yes, just so that we know where we stand, how long do you think you will need for your remaining submissions?
Your Lordship has previous experience of me offering a time estimate, and I'm afraid it was sadly inaccurate. I shall endeavour to be 15 to 20 minutes.
Thank you very much.
I hope your Lordship, however, will forgive me if your Lordship, at the outer point, half an hour at the very most.
Should we leave it there?
Court rise. Court rise.
Thank you. Yes,
Thank you, my lords. Mr. Seward and Miss Craig provided the only evidential support for the victim's identification. The jury were given a false impression of two critically important prosecution witnesses. The appellant was denied disclosure, the force of which we respectfully submit that could have been deployed against them is undeniable, and the jury were misled. Now, there is, in my learned friend's respondent's notice, the following, which is central, we submit, to a consideration of the merits. It's at tab 6 of the core bundle, my lords, at page 170, at paragraph 20, the last line on that page. The defence concession made at the trial that the honesty of the evidence of the two identification witnesses was not an issue, is of significance. It was not merely a tactical choice. It was necessarily made because there was no proper basis for impugning what they say they saw of a man the defendant said was not him. Unlike the case of Akano, they were wholly independent of other parties in the case, and there was no issue about what they saw and what had happened. Well, with the greatest of respect, what they saw and what had happened was at the core of the case and was an issue, namely the mistaken identification. But also, above that, they were wholly independent of other parties in the case, I hope to demonstrate in a short while again, because it is of such importance, why that is unfounded.
Well, with respect, not if you're merely repeating what you said this morning.
Not repeating what I've said before, I assure you, my lords, because I recognise the time. It was necessarily made because there was no proper basis for impugning what they say they saw. Well, my lords, there was a denial of disclosure which could have allowed a very trenchant and formidable impugning or impeachment of what they saw. Could I ask my lords to turn to the appeal bundle? And would you be so kind as to go to tab 73? Tab 73 is the statement of Mr. Seward. It's dated the 23rd of August 2003, which your lordships will have already apprehended because of the chronology. But this is what he says at the bottom of the page, or the foot, I should say, of page 725. A few days later, I was driving along Clegg's Lane. In other words, I was committing a criminal offence near the motorway bridge when I noticed a mobile-type police station at that location. I then became aware that a female had been attacked at that location in the early hours of the 19th of July, and the police had made an appeal for witnesses. Me and Beverley then contacted the police, stating that we had some information that may help. A very, very curious form of words, given what we know of Mr. Carson and his incident report book, which, as the court knows, is to be found at tab 66 of that bundle, which shows that at 1:16 they both present themselves at that mobile police station. Could I ask the court now to go to Miss Craig's statement? And Miss Craig's statement is dated, my lords, the 28th of July. It's at tab 67. And I ask the court to go to page 710, third paragraph from the foot of that page. Last Friday, making no mention at all of Mr. Seward, last Friday, the 26th of July, I was passing over the motorway bridge on Clegg's Lane when I saw a policeman pod with two police officers stood outside. It was then that I decided that I would tell them about what I had previously seen in case my information would assist in any way. That, I remind the court, is the date that Mr. Seward was arrested, the same day that he ostensibly voluntarily came forward to give evidence in this case. And your lordships will know, each single one of you will know, from your huge experience of prosecuting cases, and I can say this, I hope, without your lordships blushing, that in any case where a prosecution witness, particularly a prosecution witness who goes to a vital issue and is supportive and corroborative of an identification, has contacted the police, it is inconceivable, unless they are going under an assumed name which is not detected, it is inconceivable that the police will not know of their background. Those are matters which are, I respectfully submit, not in doubt. So on the very day that he comes forward, independently, he was arrested, and it is an inescapable conclusion that his involvement in this case comes as a result of his commission of a criminal offence, because he admits that he was driving immediately before he saw the mobile police station. So the essential fallacy of the prosecution's case, that these previous convictions are irrelevant and that they would have had no impact on the course of this trial in accordance with the test set out in McInnes, is fallacious. Purportedly honest, they were not. Purportedly independent, they were not. Without any interest to serve other than being civic-minded witnesses coming forward to do their public duty. Could I ask the court now, and I must stress that I can only deal with this by parity of reasoning, but taking the court to the authority of Pringle. And Pringle concerned, Pringle and the Queen, authority is bundle tab 17. Pringle concerned one prisoner giving evidence against another. And so by stating that, immediately I must state that I can only deal with this, as it were, by an analogy, by parity of reasoning. There is sufficient material, I submit, for this court to determine that on the facts as were then known, if this matter had been disclosed, and if their previous convictions, but particularly Mr. Seward's involvement, together with Miss Craig on the 26th of July, the precise circumstances of that had been known, that the defence had sufficient basis to explore this, but also deploy it in cross-examination. I take the court to paragraph 31, and I ask the court to consider the following, and it's in the middle of that paragraph. For various reasons, and I stress, of course, this refers to a prisoner, but I'm talking about Mr. Seward now, may wish to ingratiate himself with the authorities in the hope that he will receive favourable treatment from them. Then Lord Justice Ackner indicated in Beck, there must be some basis for taking this view. The indications that the evidence may be tainted by an improper motive must be found in the evidence, but this is not an exacting test, and the surrounding circumstances may provide all that is needed to justify the inference that he may have been serving his own interest in giving that evidence. And we respectfully submit, when you look, even at a distance of 20 years, the factual matrix as set out in the chronology would have been sufficient. And of course, it would have been even clearer, we respectfully submit, back in 2004. What else is there to submit? Well, there is the fact that Mr. Seward had an addiction to heroin, and for this I asked the court in due course to receive the statement of his brother, but also his own confession on television about his long-term heroin addiction, which in a programme in 2014 he said was about, goes back to about 1997 on my calculation. I'll be corrected by my learned friend who may have looked at the recording more recently than me. But it goes back to about 1997, and if I can now go very, very briefly to their records. And this can be found in the appeal bundle I'm going to start with Miss Craig at tab 9. And these were considerably more proximate, beginning, my lords, at page 139 of tab 9. You will see the summary at page 141. And you will see the record at page 142. And you can see in June 1998, theft by an employee with 10 matters taken into consideration. You can then see in the year 2000 other offences of the same type, offences of dishonesty, theft by an employee, obtaining a pecuniary advantage by deception, namely the failure to disclose previous convictions to an employer, and she pleaded guilty to all of those matters, and then a breach of the probation order in respect of those sentences. So, could I now ask you to turn to Mr. Seward at tab 10, and the summary, which I recognise is given both before and after he was a witness in this case. But certainly 2004 appears to be a fulcrum, because we know that in 2004, and it is clear from the chronology, that he was cautioned for drug offences, and he, after a period of some time without offending, so as far as is known from the record, then started to offend again after 2004. But we can see a summary of those matters at 152. Given that these witnesses were left before the jury as honest, and a concession was made, no doubt in good faith, but mistakenly, as a result of non-disclosure by the defence that they were honest, there was the centrality of honesty in the learned judges summing up. I won't say it was a syllogism, but it wasn't a legal direction, as we all know, but it was, are they honest, are they accurate, therefore reliable? This was very, very serious non-disclosure. Whether it was malignant or not does not matter, and it is not for this court to determine. All this court needs to, as I respectfully submit, focus on is what was the impact on the trial. The defence does not have any burden, and nor does an appellant, in suggesting whether this was inadvertent or whether it was deliberate. But, as is absolutely clear from the facts as are now known, it was troubling, profoundly troubling. Could I now, as I promised before lunch, take the court, again in the core bundle, to matters that we seek to rely upon in respect of cross-examining both Mr. Seward and Miss Creming in relation, or what would have been legitimate to the defence, to cross-examine them in relation to their previous records. And if one goes to tab 9, the appellant's skeleton argument, at paragraph 25 of page 193, they are set out there. The respondent, with the greatest respect, has submitted that there was no case-specific reason why the honesty of Mr. Seward and Miss Craig was in issue in a difficult identification case where otherwise the defence are simply trying to explore whether the witness might be mistaken. The denial, particularly the trenchant denial that they might be mistaken, in the most implausible circumstances, would give rise to cross-examination as to credit. I've dealt with that, or forgive me, the appellant has dealt with that at subparagraph A. Subparagraph B has been addressed, and again I emphasise that is an issue, a change of mind, the fact that there was no contemporaneous record at the time because the officer believed that it was inadmissible per se, that would have been an issue that would, again, I respectfully submit, have been carefully focused and scrutinised by the defence at that time. The discrepancies between trial evidence and initial accounts of the police, for example, as I've already stated, Mr. Seward stating that the man, after a fleeting glimpse, was 38, and his incontrovertible certainty about it, that is dealt with at D, his denial that the EFIT could have contaminated his recollection. Letter E, again, highly germane previous convictions. The witnesses' reasons for falsely claiming during their respective identification procedures that they'd not seen any media broadcasts or description in relation to the incident, when in fact they both had. I've already taken you to that in Miss Craig's statement, where you can see a reference to that. The fact that Miss Craig admitted candidly that she felt under an obligation, but where her candour may have failed her is whether that sense of obligation could have, as it were, exaggerated her certainty. And I've already taken you to the passage where I can put it no further than this, and I respectfully submit it was a withering put-down. No, the only mistake I made was not picking him out in the first place, to Mr. Samuel's question. And no need, again, to recite G, but very, very troubling circumstances as to why the witness emerged in the way he did. And as I've stated, in improper motive or taint, the defence and the appellant does not have to set out an exhausting factual foundation. There must be some evidence, but there is sufficient on the chronology. His heroin addiction is highly germane, and the court will know, or rather his use of drugs, even if heroin addiction is said to be hyperbole or overstating the matter, notwithstanding his own confession to that effect. But his use of drugs and the fact that he was cautioned for drugs in the currency of this case in October is highly germane to, and in fact falls squarely within the necessity for disclosure as prescribed by the Crown Prosecution Service itself. You see that in the grounds of appeal, where in the grounds of appeal, yes, page 158 of the core bundle, my lords, tab 4, Mr. Seward's drug use history was therefore vital context for the jury, who were explicitly instructed by the judge to assess the accuracy of witnesses, especially given his identification was made nearly 6 months on from his... I do ask the court's forgiveness. CPS legal guidance emphasising the need for disclosure of drug convictions implicitly, I should say, in fact, explicitly recognises this, and then no need for the matter to be, I respectfully submit, read out aloud. The court has read it, but what is significant is that it has not been addressed by my learned friend and respondent in his argument. And it is the CPS's own guidance. I asked the court to take Dr. Cloft as read. I respectfully submit that her statement does not go to the ultimate issue and does not offend against that principle, and that it is credible and reliable, and if admitted could have a determinative effect, that essentially section 23 is made out. And now, having dealt with grounds 1 to 5, I deal with the issues, as it were, in relation to leave.
Well, you've made your submissions about the merits of the argument.
Hamilton probanda, my lord. That is the...
Yes. Well, in Hamilton, the court identified that in circumstances where it's clear that an appeal will succeed on one ground, and the question was, is the court required to consider all or any other grounds, the court made clear that it's a matter for the court to decide in the exercise of its discretion, and it suggested a non-exhaustive list of factors which might well be relevant to deciding where the interests of justice lie in a particular case.
Absolutely, my lord.
It's perfectly clear it's a fact-specific decision, depending on the circumstances of each individual case.
And this, in our submission, is a case of such importance and such evident merit that whilst, as I postulated, fresh scientific evidence can quash a conviction, the vital question of the real possibility of an acquittal in 2004 is important for the proper vindication and the wider interests of justice in Mr Malkinson's case. Deal with it very briefly, my lords. The Article 6 rights of the ability to challenge and confront denied at trial, and which blighted an appeal, particularly given the fact, although the appeal was taken principally on other matters to do with contamination, which I need not trouble the court with, but there were two grounds of appeal that went to the binary decision, which I've respectfully submitted was a fundamental obstacle to conviction, a winning point for the defence, and also the credibility of Miss Craig. The overall importance, as Hamilton points out, to the parties and to the public of these further grounds, even though the appeal itself will be successful, because they go to the vital issue of disclosure, which is of fundamental importance to this court and to the criminal justice system and the administration of criminal justice. And as I stated at the outset of my submissions, I was not here to waste the court's time or valuable resources, but to hope that the court, in determining these issues, would provide guidance that might prevent the dreadful recurrence of this for others. The furtherance of the overriding objective to deal with the case expeditiously but also justly. These matters are of very narrow compass. The matters are a very narrow compass, and they can be addressed expeditiously, we submit. The particular importance to the appellant in relation to his character and reputation, need I say any more about that? I think, if I may say submit, not. The next matter, whether the additional ground relates to an issue which should be resolved in order to maintain public confidence in the criminal justice system, the court will know from the submissions advanced that this is central to that question. There is also a postscript to the grounds of appeal that deals with document retention. And my Lord, Mr. Justice Goose, was a member of the court that dealt with historic appeals in Warren and others, where the court emphasised the importance of that at paragraph 101 of that judgment at page 288. Whether the additional ground raises a legal issue, it may not raise black letter law, but it raises huge procedural questions of undeniable importance in relation to disclosure, which, as the court knows, is fundamental to a fair trial. Vindication, and appropriate vindication, in the sense of the appellant, is a core value we respectfully submit, particularly given the length of time served in this case. And we respectfully submit that the matters will not take great time or expense. The court has already heard them de bene esse. There will be no undesirable delay. I respectfully submit that there is a very, very important principle. As consistent with this court's duty, although this court's principal focus is to determine whether a conviction is unsafe, we respectfully submit that these convictions were unsafe at the time without the need for subsequent scientific evidence that the cumulative effect of the material non-disclosure as to the error of the doctor, which negatived a winning defence point, and the material non-disclosure that would have wholly undermined confidence and credibility in the independence and the reliability of the only supporting evidence from those two witnesses, is therefore, we respectfully submit, fanciful for the respondent to suggest that they're irrelevant, that they have no impact, and that the verdicts would otherwise have remained the same. Those are my submissions on behalf of the appellant.
No, thank you. No, thank you very much indeed, Mr Henry. Yes, Mr Price.
My Lords, I've provided two short documents to the court.
Yes.
There is the respondent's notice, and there is the more recent and shorter document that was intended to deal with any outstanding matters that arose in the skeleton argument filed on behalf of the appellant.
Yes, thank you.
Knowing that the court will have read both, I propose, if I may, to take matters succinctly.
Yes.
My Lord, so far as ground one is concerned, the respondent accepts without qualification the accuracy of my learned friend's description of the primary facts established by the new scientific evidence. And when I refer to the new scientific evidence, I refer to that which was relied upon and commissioned by the Criminal Cases Review Commission, and which led to this case being sent back to this court. And I refer also to the very detailed report by Ms. Cherry that was commissioned by the Greater Manchester Police, and I'm grateful to my learned friend's gracious remarks concerning the benefit which that report has conferred upon him and his client in support of this appeal. Not only do I accept without qualification the accuracy of the statement of the primary facts, I accept and commend to the court the submissions which have been made about its forensic impact. It is scientific evidence of great weight, which has considered many articles and exhibits. Not one of the results implicates this appellant, and there is a combination of them which significantly identify an alternative, and this is the important word, single contributor. My Lord, the only issue that I would take with what has been said about the respondent's position on count one is that our concession in that regard, if properly made it is to be construed as narrow. Grounds 2 to 5 are concerned with criticisms of the trial process. Ground 1 goes to the central issue in the whole case, the identity of the person who undoubtedly carried out a most appalling attack upon that young woman. And the fresh evidence, should the court admit it, as both parties invite it to, goes to that very issue. And even were it the case that I was able to submit to the court, and I'm making no concession when I say this, I say it hypothetically, even were it the case that one was dealing with an investigation and a trial of perfection, and in which no possible criticism could ever be raised, that would still not diminish the impact of the fresh evidence that is the foundation for ground one. So for the respondent to have conceded the position on that ground is, with respect, not to be construed as a narrow concession. My Lord, unless I can assist further, that's all I propose to say on ground one. What I would like to deal with next is whether, in the light of the effect of ground one, should the court accept that the positions of the two parties is correct, that the evidence should be admitted and that it does render these convictions unsafe, is whether it is in the interests of justice for the court further to consider the other matters. My Lord, you've been taken through the considerations in Hamilton and Post Office and Hamilton, forgive me. When the court comes to consider the matter, could I please ask that it takes account of the following submissions on behalf of the respondent. On the question of vindication, which in circumstances such as this the respondent would acknowledge is an important consideration, with respect, on the, as we have acknowledged it is, persuasive analysis advanced on behalf of the appellant, it may be thought that ground one, if it is upheld by the court, offers a vindication of this appellant in a way that the other grounds do not. Secondly, my Lord, because leave is required on these other grounds, complaints of prosecutorial misconduct, if I can embrace them all with that phrase, were considered by the Criminal Cases Review Commission, and the Commission was not persuaded to refer the case distinctly on such a basis. Explicitly, they do not for themselves assert that the complaints advanced to them are made out. And I would add this, and I submit that in the light of the considerations in Hamilton, this is an important feature of this case. It is, we say, rightly not submitted by or on behalf of this appellant, that whether one looks at grounds 2 to 5 separately or cumulatively, it has not been submitted that those complaints amount to an abuse of the process of the court. Thirdly, my Lord, there is here, as previously stated, no question of a retrial. And fourthly, these grounds do not raise a point, the resolution of which would provide guidance as to the proper interpretation of a statute or would clarify conflicting previous decisions on a point of law. So, my Lord, those are the matters that I would ask the court to take into account when it decides whether it is in the interests of justice to rule on the question of the questions which are raised in grounds 2 to 5.
Yes. Can I just ask you this, Mr. Price, in particular in relation to the first of the submissions you've just made in relation to vindication?
My Lord, yes.
I understand, of course, the point you've made that ground 1, you suggest, provides vindication in a way other grounds do not and
yes.
cannot.
Yes.
Do you want to say anything one way or the other about Mr. Henry's submission that if the new scientific evidence had been available 20 years ago, Mr. Malkinson may not have been prosecuted at all?
Perhaps I might answer that question in this way.
You don't have to answer it. I prefaced it by saying, do you want to say anything?
My Lord, it is a fair and cogent submission.
Right.
It is difficult to see how a responsible prosecution lawyer looking at this evidence in the round, including all of the scientific evidence, it is difficult to see how they might consider that the Code for Crown Prosecutors test is met. I hope, my Lord, that's a fair and square answer
Thank you very much.
to the question.
Yes, thank you. Right, so you've addressed what logically is the first question: should the court
Yes.
consider these grounds at all?
Yes.
And if yes, then the court will obviously need to consider the individual grounds.
Then can I make some short submissions
course.
on the grounds
Thank you.
themselves? My Lord, I've already made the point. May I just pray it in aid in support of what I'm about to say, that these grounds were considered but were not the subject of a distinct referral by the Commission. So there's that general point to make about them all. I propose in my oral submissions to focus on the question of impact. I'm not going to address the court further on arguments about disclosure, whether they were or were not, or whether they ought or ought not to have been. It is clear from the record that the photographs did not play a part in the trial. It is clear from the record that the convictions of the two identifying witnesses did not play a part in the trial. What I have to say is going to focus on the impact of the absence, if I can put it in that way. My Lord, as the respondent sees the photographs, and as Mr. Henry fairly put it, quite incidentally, and in effect by chance, they reveal that the fingernail on the middle finger of the right hand is undamaged. Whether they go further than that perhaps matters not in the light of the way that I'm going to ask the court to deal with this if the court thinks that this is right. Evidence going to show that the middle finger on the right hand was undamaged is sufficient to demonstrate that when one comes to consider an apparent conflict between the complainant and the doctor as to which hand it was, the photographs seem to make it clear that the error was one of the doctor and not of the complainant. But, my Lord, it is equally clear, I submit, that this conflict between them played very little part in the trial. And it was not thought to be of importance in the conduct of either party's cases. Because, as my Lord has observed, the conflict was apparent on the papers, and yet the doctor's statement was read. She wasn't required to attend to give evidence. And the conclusion I submit that one is driven to in those circumstances is that this did not become a matter in the case, a matter in issue in the case, until the judge commented in the way that he did. And given that the doctor had not been called, was entitled to, because after all, if the statement had been read, the judge was entitled to proceed, indeed had to proceed upon the basis that it seemed to be accepted that that therefore was the correct account of matters. But, my Lord, the first thing that needs to be said about the judge's observations upon it is that they do not amount to a direction of law, which the jury would be obliged to follow. They were not even an overt comment. They were more in the form of a rhetorical question. And the observation about the significance as it seemed might have been the case at the time, that the complainant was in error about which of the fingernails was damaged, was combined with other observations about the circumstances in which that recollection took place. Not merely the fact that it was in the middle of this shocking attack, but that this was something that she said had happened immediately before she lost consciousness. And so the respondent's submission is that to focus on that particular feature of what the judge said to the jury is to overlook and disregard the importance of the context in which it took place, all of which remains applicable, all of which remains correct, and all of which remains true. And so the respondent's short submission is that even accepting that the photographs help one to resolve this issue that arose between the complainant and the doctor, and it demonstrates the complainant was correct, it does not lead to a situation where the observation made by the judge relying in part on that would be such as to render the verdict taken on its own unsafe. My Lord, unless I can assist further, those are my submissions on the photographs.
No. Thank you. Just before you move on, Mr. Price, absolutely no desire to embarrass anyone, but I'm just a little concerned about the welfare of a lady sitting at the back of the public gallery. Are you all right, madam? I'm not offering medical advice, but I think some water may be brought to you. And can I simply say, if you feel you need to leave, please don't be in the slightest bit embarrassed. You're in the awkward position in the middle of the row, but don't be worried at all. If you feel you need to leave, we will fully understand, and no one will think it in any way amiss. All right? But I think some water's arriving. Yes, Mr. Price.
Pausing just for a moment, my Lord, I had meant to preface my submissions on the photographs with this general observation, and may I deal with it now before I come on to deal with the convictions? Having made the unreserved and I hope correct concession that I have in respect of ground one, although I'm addressing the court in resisting submissions on these other grounds, I would wish to make it clear that that is not to be interpreted or to be understood as going in any way behind the earlier concession or qualification. I'm dealing with these points discreetly, given that they are being raised in addition to the ground upon which I've made the concession.
Certainly. Thank you.
My Lord, what I submit is quite apparent.
And I'm so sorry, just before you move on, I'd better just check. Speaking for myself, the impression I'm getting from the discussion earlier this morning, and in particular my Lord Sir Robin Spencer's identification of the statement of the photographer, I'm wondering whether perhaps what happened was that there was a bundle of photographs which were used at the trial, and then a bundle of other photographs which weren't thought to be critical to the trial and which, one way or another, don't seem to have featured at all. But my factual question for you is, do we know exactly what was in the bundle which was used? Do we have an index of it, or even a copy of it? I think Mr. Greaves-Smith is shaking his head behind you, which may be a clue.
I have to confess, I'm not able to answer that question as I stand here now. It may be, if I were to speak to Mr. Henry, between the two of us, we might be able to do so.
Well, just to be absolutely sure, there weren't any photos of arms or hands in the album that was used.
Henry draws attention to paragraph 98 of the summing up, in which the judge describes what they show.
Just a moment, thank you. Right. Yes. Thank you very much indeed, Mr.
I have
Henry.
certainly seen the photographs. I've seen the originals. I have not, in preparing the case, seen the album that was used at the trial. But my lord, I'd invite the court to rely upon the judge's summary of them there in the summing
Well,
up.
that's a very good guide to what went to the jury.
Yes.
Of course, we're all familiar with what
Quite
goes
so.
to the jury being
Quite so.
extracted from larger bundles.
I've set out in writing, I've set out the respondent's position in writing on the issue of disclosure, though, as my lord will also have seen, I nevertheless indicated to the court that it was accepted that they had played no part in the trial, and that I wasn't seeking to resist their admission as new evidence by the court. I have confined my submissions to a consideration of their impact.
Yes, thank you very much indeed. Yes, I'm sorry to have interrupted
Not
you.
at all, my lord. As the court will have seen, I take a slightly different position in relation to the evidence of the convictions, because a relevant consideration under Section 23 is the issue of admissibility. Now, first of all, my lord, I recognise that the admissibility regime in 2003, and before the coming into force of the the trial was in February 2004, but the admissibility regime which will have applied at the time of this trial is not as strict as it is now. The only issue would have been then one of relevance, and frankly, one knows as a matter of practice that very rarely was there argument about the admissibility of material of this sort. But nevertheless, we are here considering the position in 2023, and we have been working under a different regime relating to the control of admissibility of material of this kind for many years. And ultimately, the test is necessity or expedience in the interests of justice. And I do therefore feel able to ask the court to consider the position as it might be now under Section 100, and whether the evidence of these convictions in the context of this case could be said to have substantial probative value. Clearly, the issue to which they're said to relate would be a very important issue in the case, but the question would remain whether they have substantial probative value. My lord, I listened with care to Mr. Henry's submissions. As I've already mentioned, it is not said that there is here evidence of a manipulation or misuse of the process of the court. And as I understand it, it is not suggested that this material could give rise either to a submission to this court or could have given rise to a realistic submission to the trial court, that the identification procedures themselves were undertaken other than with integrity. If Mr. Henry was going to invite the court to submit that this evidence could have supported a submission that the conduct of the procedures themselves were tainted or may have been manipulated or dishonest, then one hopes that that would have been spelt out in the plainest of terms. So I'm working upon the basis that it is not suggested that it goes to such an issue, and that the only question, therefore, is whether it is relevant to considering why it is, or whether it could have undermined the fact that both of those witnesses picked out at an identification parade the same person who had already been identified by the lady herself. My lord, when one looks at the authorities that are relied upon by the appellant, it is quite clear that much turns on the particular facts of the particular case, as is so often the position. My lord, I learned as we were going along that the electronic bundle that I was provided with has a slightly different pagination. But may I take the court to the case of Parks in the electronic bundle? I'm looking on my bundle at page 201, and it's page 3 of the report, and it's the paragraph to which the court were taken, beginning the second question is whether it is relevant.
Yes.
Now, this was a case where the character of the witness in question was the character of the only witness who had provided evidence of identification in the case. And the court says this: the only issue before the jury was whether her alleged identification of the appellant was one which they could safely accept. My Lord, that is a succinct statement of the issue that arose in respect of the witnesses whose character we are considering in this ground of appeal. The court has felt very great doubt about whether these convictions were really relevant to that issue. No one has suggested that she knew of the appellant before. That applies here. That she had any grievance against him. That applies here. Against his family. Or that she had any dishonest motive for identifying him. When, however, the court goes on to consider the alternative position, it is quite clear that they do so by particular facts of that case, and in the case, as I have said, where the evidence against the appellant in that case depended wholly upon the identification provided by a witness whose answers were not always quite consistent on the point, etc. But the issue in this case was whether the evidence of the identifications of these witnesses, whom, as I understand it, is accepted, did drive past the scene that night, who it is accepted did see the man who carried out the attack upon the young woman, who it is accepted did, in a properly conducted procedure, pick out this defendant. The issue which arose was, why was it that that was the same person as had been identified earlier by the lady herself? Now, my Lord, if on that basis I fail to persuade the court that the material ought not to have been admitted, or would not be admitted, there nevertheless remains the question of its impact, because the mere fact that evidence may be admissible, it doesn't automatically follow always that it would be, as if I can put it this way, forensically wise to use it. Because for all that with hindsight one might say that one would have done, there is a reverse side to the coin on the facts of this case. If it be accepted that these witnesses were wholly unconnected to any of the other parties in the case, did just happen to drive past and did genuinely see this assailant and did honestly pick him out at an identification parade, there would, I submit, be obvious risks in then being seen to question them about what might appear to be the jury are wholly unrelated matters and have nothing to do with the question of whether in their picking out of the defendant on the identification parade they're accurate or not. There would, I submit, be a risk that a jury might just as easily conclude that this is something of a distraction and doesn't focus on the question which they, the jury, are being asked to decide. My Lord, that's all I wanted to say on the question of the evidence of the convictions, unless I can assist the court further.
Thank you.
A few words, if I may, on the heroin addiction. First of all, it applies to only one of the three witnesses. Secondly, the respondent does, with respect, submit that the expert report which has been prepared to do with this issue goes way beyond what an expert may legitimately comment upon in circumstances of this kind. My Lord, it will be the experience of everyone in this court that when a toxicologist is called at a trial, they will always discuss hypothetically what may be the effect upon a person of the ingestion of a substance in quantities of this or that. What they will never do, and what they should not do, is to offer an opinion on what their effect will have been on the person in question, either generally or on the occasion at all. So, for those two reasons, it goes to only one of the three witnesses. And in the end, the evidence which is deployed in support of it goes way beyond that which is permissible. We submit it ought not to be admitted. Can I assist the court further?
No, thank you.
Thank you, my Lord.
Yes, did you want to reply to any of that, Mr Henry?
I'm very grateful, my lords. I'm dealing, if I may, with Dr. Clough first, and it's at paragraph 30 of the skeleton, which is at tab 9. And we simply adopt, in response to my learned friend's criticism of Dr. Clough's report, that matter. What is important to concentrate upon, however, in relation to ground 5, and its contradistinction to ground 3 and ground 4, is that ground 3 concerns the credibility and truthfulness of the supporting witnesses' evidence on the basis of their criminal history, whereas ground 5 concerns the accuracy and reliability of Mr. Seawood's evidence on the basis of his long-term drug use. And the jury, the possibility that the jury may, for example, consider a witness to be even an honest person but mistaken in their account because of the defects in their eyesight or memory, so mutatis mutandis. They might have thought that, for example, arguing against myself, that he was an honest witness, but that his reliability had been compromised by long-term drug use. But could I now address very, very briefly the issue about, for example, whether we've suggested that the identification procedures were, as it were, corrupt, why we have not submitted correctly, as it is said, and I'm very grateful for my learned friend's approbation, that this is not a case of an abusive process. The answer is plain. We cannot, because after this effluxion of time, we are unable to do so. It's not that I'm pulling a punch. Again, the pernicious effect of non-disclosure and long-term non-disclosure means that matters which would have been as fresh as paint back in 2004, for example, as to how Mr. Seawood became involved in this case, are now, forgive the cliche, lost in the mists of time. But returning to Pringle by analogy, there is sufficient foundation so far as his interaction with the police to show that this is deeply troubling and therefore would have had impact, and we respectfully submit, if deployed carefully, significant impact. But even before that, on the premise that it must have been and would have been ordinarily disclosable, it would have set in train a number of requests pursuant to the Criminal Procedure Investigations Act, which may have culminated in a Section 8 application. Can I now, in the same context, as it were, again, I can't say that Miss Craig's identification was corrupt, but she did not pick out Mr Malkinson during the procedure. And again, if proper disclosure had been made, then, particularly given her nexus, her relationship, welded together, as it were, to Mr Seward, anything which perhaps damaged his independence would have damaged her. And of course, the other matter that would have been replete for cross-examination as to credibility would have been that Mr Seward had seen the EFIT beforehand, would have no doubt discussed matters with his partner, who performed the identification 6 months before him, and any denials of contamination could have been, as it were, controverted by cross-examination as to his record. Now, my lords, I'm slightly at a loss because we know that the test at that time, which is the test that the court has to apply, is the test of relevance. At the 2003 trial, my learned friend says the applicable test would have been one of mere relevance, that is page 171, but correctly applying even that lower threshold, it is submitted the result would have been the same. We don't shy away from it, whether it's section 100 or whether it's the test of mere relevance. This was disclosable, this was relevant, this was admissible, and we respectfully submit on any proper consideration of the matter, it would have had a damaging effect. They were supporting witnesses. It is no use, as it were, drawing a distinction with Parks, the complainant in that case being the sole identifying witness. Here, Miss C was supported by two witnesses who were vulnerable to attack, and that attack was denied because of non-disclosure. And there's no need for me to repeat that which I have already submitted and which you will find in writing, of course, at the skeleton at page 25. But my learned friend says, well, we must be careful that we're not, as it were, influenced by the benefit of hindsight and that this could have been counterproductive. The whole prism through which one looks at a case is dependent upon disclosure. That which is used, but also fundamentally that which is unused. And this would have put a considerably different perspective on the way in which they not only came into the case, arguably, because if disclosure had been made, then further inquiries would have been no doubt undertaken by the defence, but the way in which one could look at their evidence and the way in which one would run the trial. My learned friend, when asked by my Lord Justice Holroyd in response to my submission, may Mr Malkinson have not been prosecuted at all? And my learned friend said that that was a fair and cogent submission based upon a responsible prosecutor analysing the code for Crown prosecutors. Well, so similarly, we respectfully submit, if the proper position had been known about grounds 2, 3, 4, and 5, then given the fact that this was a very, very difficult identification by Miss C, given the baggage that came with the supposed supporting witnesses, there is an argument that he may not have been prosecuted at all on that basis as well. But I'm very grateful to my learned friend for stating that ground 1 provides an unreserved vindication of Mr Malkinson. I'm very grateful for that because I respectfully submit upon that one can properly submit to the court without exaggeration that although the word innocent has not been used, because my learned friend confines himself to the legal test under the Criminal Appeal Act, the essence of that submission is the same. But there are core process values, so far as the administration of justice that have very, very sadly and lamentably fallen far short of the mark in his case. And that vindication that he may have been acquitted in 2004 is vitally important for him. I can only, before closing, submit this. These very serious departures we submit from the Criminal Procedure and Investigations Act deprived and denied Mr Malkinson of the ammunition that he needed to challenge the prosecution case. It went centrally to the issue of identification. Ground 2 goes to identification. My learned friend submits that it does not. It goes directly to the issue of identification and the binary choice that the jury had. And 3 to 5 go to the credibility of the ostensibly independent witnesses. Again, I emphasize, it is not for this court, and this court, no doubt, could not, in any event, pronounce on whether that non-disclosure was malignant or inadvertent. But non-disclosure it was, and it deprived the appellant of the vital material required to explore the merits of the prosecution case and to confront it. And it's for those reasons we respectfully submit that the court ought to grant leave in this case for those other grounds, unless I can assist the court further.
Can I just ask you about the mechanics of the Viper procedure that would have been undertaken? I know you've got the record. But 3 separate Viper identification procedures, one for each witness. Obviously, the photograph of the appellant was in the lineup, so to speak. But do we know whether it was the same set of other photographs, in a different order, obviously, for each of the parades or not?
I believe not, but forgive me, my lord, if you will. No, they were different.
Different for each one?
Thank you. Now, Mr. Henry, Mr. Price, will rise shortly to take stock of where we're up to. We'll just rise, as I said, and take stock of where we're up to.
So rise.
Mr. Henry, there was another matter you wanted to raise with us, we understand.
Your Lordships, I'm most grateful. I meant to take the court, in response to my learned friend, to the case of Underwood, which is at paragraph 20, forgive me, tab 21 of the authorities bundle, a case in which there was non-disclosure of witnesses' previous convictions. The appeal was not allowed, but that was because there was a compelling circumstantial case which is recited by their lordships at paragraph 31 at 257 and 258. But what is of help and assistance to this appellant, Mr Malkinson, is the judgment of the court in Farrell, an unreported case dated the 20th of March 2000, which is referred to at paragraph 28, and the law is taken from paragraph 7 of Farrell, where Lord Bingham of Cornhill, the Lord Chief Justice, said, "Thus we have a clear and simple case in which the convictions of the prosecution witness were not disclosed when they should have been as a result of inadvertence or oversight, What is the effect of such non-disclosure if a defendant is convicted and the evidence of convictions on the part of the prosecution witness then comes to light? There is no simple and straightforward answer to that question. The answer will depend on the weight of the evidence in the case apart from the evidence of the witness whose convictions have not been disclosed. The greater the weight of the other evidence, the less significance, other things being equal, the non-disclosure is likely to have had. I ask the court to reflect carefully on the circumstances of this case, and apart from the unsupported identification of the complainant, there was nothing else. The answer will also depend on the extent to which credibility and honesty of the prosecution witness, whose convictions have not been disclosed, is at the heart of the case. Well, I don't need to address the court on that because, of course, the way in which the case was left and the fact that these were vital supporting witnesses. If, as here, the prosecution witness whose convictions have not been disclosed is the only witness against a defendant, well, obviously, circumstances differ, but these were two vital supporting witnesses, and his credibility and honesty are squarely in issue, and the jury are led to believe that the witness is of good character when such is not the case, then there is strong grounds for contending that the conviction is unsafe. Now, obviously, and I assure the court these are the final words I submit, until one has disclosure, one can't make a decision on how one runs the case, but there were dubious and unsatisfactory elements to the identification, and I say nothing further, and I'm extremely grateful to the court for allowing me to take you to that authority.
That's right. Thank you, Mr. Henry. Thank you. Then we'll state briefly the position. Almost exactly 20 years ago, on the 19th of July 2003, a young woman was attacked and raped as she walked to her home in the early hours of the morning. On 10th February 2004, this appellant, Mr Andrew Malkinson, was convicted of offences of attempting to choke, suffocate or strangle that young woman to whom we have referred as C, with intent to commit an indictable offence, namely rape, and 2 offences of raping C. He was subsequently sentenced to life imprisonment. He, in fact, spent over 17 years in custody, very substantially beyond the period specified by the trial judge as the minimum term. Throughout, he has denied committing any of the offences. He now appeals against his convictions, the appeal coming before the court by way of a reference from the Criminal Cases Review Commission, CCRC. As a result of scientific advances in relation to DNA testing, it became possible in 2022 for tests to be carried out on samples which had been collected during the original police investigation and had been preserved across the years. The outcome of that testing was of twofold importance. First, it gravely weakened the case which the prosecution had presented against Mr Malkinson at his trial. Secondly, it directly implicated another man to whom we have referred as Mr B. That development led the CCRC to refer the case to this court pursuant to Section 9 of the Criminal Appeal Act 1995. The first ground of appeal advanced on behalf of Mr Malkinson reflects the reason which the CCRC gave for their referral. Further grounds, grounds 2 to 5, have also been put forward. It is recognised on all sides that this court has a discretion to hear and determine those grounds, even if the appeal will be allowed on ground 1. We're extremely grateful to all counsel for the submissions we have had on all the matters, including those in respect of which the court will need to decide whether to give leave. We're also grateful to all those behind counsel on each side for their work in preparing and presenting this important appeal. The submissions we have heard about grounds 2 to 5 have raised a number of substantial and important points, and the court wishes to take time to reflect upon them. For that reason, and having regard in any event to the time we have reached this afternoon, it is not possible for the court to give its full judgment today. However, we must keep Mr Malkinson waiting no longer to know the outcome of his appeal, for we are able to decide the outcome of the appeal on the basis of ground 1 alone. The respondent has not sought to resist the appeal on ground 1, and we have no doubt has acted entirely properly in that regard. Having considered for ourselves the new evidence and its effect, we have no doubt that the new evidence shows these convictions to be unsafe. Accordingly, we formally receive the new scientific evidence as fresh evidence. We allow the appeals against conviction in relation to all the offences, and we quash the convictions. We reserve our judgment. We will give it in writing in due course. In it, we will give our decisions on the issues of leave and, if appropriate, the merits of grounds 2 to 5, and we will state the reasons for all our decisions. But whatever our decisions may be in relation to grounds 2 to 5, the appeal succeeds on ground 1, and so, Mr Malkinson, having waited so many years, you leave the court a free man, no longer subject to the conditions of your life licence. We must finally return to the question of reporting restrictions with which we began the hearing this morning. We're again grateful to all who have assisted us with submissions. We make the following directions. The order made pursuant to the Sexual Offences Amendment Act 1992 on the 3rd of May this year remains in force and will remain in force unless varied or discharged. Accordingly, during the lifetime of the lady to whom we have referred as C, no matter may be included in any publication if it is likely to lead members of the public to identify her as the victim of these offences. On the 3rd May, the court also made an order under section 4.2 of the Contempt of Court Act 1981, postponing the reporting of any matter which would lead to the identification of the man we have referred to as Mr. B. We vary that order as follows. Pursuant to section 4.2 of the 1981 Act, B, or include any matter which may lead members of the public to identify him. This part of our order will continue until further order of this court, or, if later, until the 16th August 2023. Mr. Price, can we just spell out the practical effect of that? The 16th of August is the Wednesday 3 weeks from today. In the usual way, this being an order derogating from open justice, the parties or media representatives may apply to vary or discharge it. But in particular, if the Crown Prosecution Service within the 3 week period makes a decision not to charge Mr. B, then that of course must be notified to the court immediately.
Yes, of course.
If within that period the prosecution decide to charge, or wish to inform the court that they need more time to make a decision, then it will be necessary to apply to the court for a further order or an extension of the order as may be. Okay. And that any such application should please be made on notice to the appellant's advisors and also to the press association, so that the media can have an opportunity to comment if they wish to do so.
Thank you, my lord.
We hope that provides a practical answer to the various issues we've raised. Very good. Our thanks to all concerned.